कामू कौन प्रॉब्लम का स्टार्टिंग छे हाथ दादा के तो का क्यों का तकलीफ है कहना लेकिन इज इट द वे के नो पर्सनल वे तो अथवा दादा के नो का वो व्हाइट शर्ट नहीं मिली क्या तो हाली के बटे
Which matter, CRP. I made it in the month of March, Malad. Yes. It was directed to posted at 28, Malad. It was posted before another day. And yesterday date was given where it was classified as a motor vehicle. Instead of cities, Malad. And this Malad will become tomorrow.
That what is that urgency in motor vehicles?
No, not motor vehicles. CP similar data come up before your lordship. And your lordship was directed to post a matter 28. 28
Yes.
Yesterday date was given and again. And
when is property.
So during the eviction proceedings against me by my landlord,
Yes.
she entered into an agreement to sell with me. She did not honor it.
Yes.
Later, she obtains a decree for eviction that was put to question before the revision court at Udupi.
Yes.
Udupi court affirmed the orders of the eviction petitions ordered for bona fide use and occupation. With regard to the agreement to sell what she had executed in my favor as a tenant, suit was filed. Now it has been decreed. Now the matter is pending before the first appellate court in RFA before this court because of the pecuniary jurisdiction. In the meanwhile, now she is trying to she obtains a stay of the RFA. Yes. Of the operation of the decree. And on the eviction petition side, now she has moved the court for eviction order, and there is simply an order by this court of a different bench combination. Since RFA is pending, let it also come along with it. That is all. There is no judicial order as such. It may be brought up on Monday. Should I have to mention the RSA number which is tagged along with that?
Yes, yes. You give that RSA number.
RSA 8.
So let us see that. Let the matter posted Monday. If there is no order, then we have to pass an order. Otherwise, they will not post along with this unless there is a judicial order. Because if it is a different roster, then Chief Justice permission has to be required. Yes, Monday we'll see that. Yes.
Not the CRPs of the year 2016 pertains to a box property, my lord, where now eviction notice has been taken up on Monday.
Yes.
The CRP proceedings before the trial court was stayed and the order had been extended to further orders.
Yes.
Trial court is insisting on an extension. There's a short one, trial court matter on Monday, matter kindly we had tomorrow.
Let us hear 22 minutes. Still is admitted. As the MFA is against the dismissal of the misdemeanor to set aside the expert order. This matter was heard on 3/8/2022 by a lordship. It was directed the appellant to produce the order copy. their appeal is not being posted. I filed application for vacating of interim order also. Since appeal is admitted, office is telling that.
Next.
2018. Date, specific date.
Yes, next Thursday. Yes.
For adjournment, for page wise adjournment, page number 1, serial number 1 to 5. Page number 2, 6 to 10.
Petition number 4, HP Manjunath, Your Honor, is already oral again.
Page number 2, serial number 6 to 10. Page number 3, serial number 11 to 14. Page number 4, serial number 15 and 16. Page number 5, serial number 17 to 21. Page number
Take, office objection is there. I will going to complain.
Week's time is granted to comply with officer.
Please.
Page number 6, serial number 22 to 25. Page number 7, serial number 26 to 29. 8, serial number 30 to 34. Page number 9, serial number 35 to 39. Page number 10, serial number 40 to 47.
My lord, serial
Your
number
lordship may
41, my
can be-
lord.
Yes.
Serial number 41, my lord. I want
Yes.
to for respondent, my lords.
Yes.
I'll need a week time, my lords, because I want to file some more documents which have been left by the petitioner herein.
Yes, sir. The request of council for the respondent next week.
My lord, serial number 43.
Yes.
Serial number 43, your lordship may kindly have it next week. My friend expired, my lord, today, unfortunately. Next Friday, your lordship. End तारीख है.
Yes. Karnataka Council for the appellant has filed a memo stating that enough a OS, the suit itself has been disposed of. The appeal become infructuous. The memo dated 31/8/2023 is taken on record. The above appeal is dismissed and become infructuous.
My lord, serial number 43.
Yes,
My
yes, it is
friend
urgent,
expired,
Mr.
my lord.
Yes,
Your
it is
lordship may have
urgent.
it. Yes, sir.
Urgent.
Kindly.
Adjournment put it there.
40.
Page number 11, serial number 48 to 55. Page number 12, serial number 56 to 61. Page number 13, serial number 62 to 65. Page number 1 for dismissal, serial number 1, Abdul Wajid essay for appellant MS Nagaraja.
Office has granted granting more than 1 year time to comply that office objection. Office objection is not complied. Even when the matter is posted before the register, several location, none appear for the appellant. The office objection has not been complied. Even on 38/8/2023, when the matter is posted before this court, none appear for the appellant. The office objections are not complied. Hence, there is a direction to post this matter on 31/8/2023 on the top of the list under the caption for dismissal. Even today, when the matter is posted, when the matter is called, none appear for the appellant. It appears appellant is not interested in prosecuting this appeal. Hence dismissed for non-prosecution.
Serial number 2, Purushottam for appellant. Serial number 2, Purushottam.
Right now. Taking more than 5 months time. Office objection is not complied. And then the matter is posted on 17/8/2023 before the registrar. None appear for the appellant. Office objection is not complied. The matter is posted before this court on 29/8/2023. None appear for the appellant. Office objection is not complied. Directed to post this matter on 30/8/2023 at the top of the list for orders. Even on 30/8/2023. None appear for the appellant. Directed to post this matter today. Top of the list under the caption for dismissal. Even today, when the matter is called, none appear for the appellant. Here that appellant is not interested in prosecuting the appeal. Hence dismissed for non-prosecution.
Serial number 3, Prakash Rao for appellant.
Wait of taking more than 6 months. Office objection is not complied. Even when the matter is posted on 17/8/2023 before the register. None appear for the appellant. Office objection is not complied. Even on 29/8/2023 when posted before this court. None appear for the appellant. There is a direction to post this matter on 30/8/2023 at the top of the list for orders. Even on 30/8/2023, none appear for the appellant. Direction to post this matter today on top of the list under the caption for dismissal. Even today, when the matter is called, none appear for the appellant. Office objection is not complied. Appears that not interested in prosecuting. Hence dismissed for non-prosecution.
For order, serial number 4, Raghu Prakash Babu D for appellant.
Appear for the appellant. Post this matter tomorrow under the caption for dismissal.
613M for petitioner KV Narasimhan. Government advocate.
Yes, Mr. What is this? This represents in the name and signature of the petitioner number 4. Who is petitioner number 4? Yes.
Signature is Uma Manjunath. HP Uma Manjunath signature already.
You know, what is the name of the this thing? Manjunath, how can become Uma Manjunath?
Signature.
Uma Manjunath. Why?
Our signature of Uma Manjunath signature.
Where is that?
Uma Manjunath ಅಂತನೇ signature ಹಾಕಿರೋದು. Video ಇದೆ. Uma Manjunath.
Yes. Overall ಆಗಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
Overall again from the order sheet ಅಲ್ಲಿ mention ಆಗಿರಲಿಲ್ಲ.
ಇಲ್ಲಿ ಯಾವತ್ತು overall ಅದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. Office has raised the objection
last
regarding
hearing,
discussed
senior
name of exponent. Petitioner submit that with regard to office objection, the non petitioner granted weeks time to comply.
don't mention for the side but
Petitioner to learned counsel accepted with the office objection overruled. What about that other office objection?
Oh.
Regarding to that other office objection, learned counsel petitioner is granted 1 week's time ಅಂತ ಹೇಳಿದ್ದಾರೆ.
office submission already complied.
ಮತ್ತೆ ಆಗ್ತಾರೆ ಅದನ್ನು ಅಂತಾರೆ ಆಫೀಸ್ objection ಓಡಾಡ್ತಾರೆ ಮತ್ತೆ ಅದು ನೆಟ್ ನೋಟ್ ಆಗ್ತಾರೆ. Also, yes, we will just verify from the registry. Unnecessary it is posted.
Because usually a petition.
Yes.
Then I had tried to thereafter converted as CRP. First my friend married so that I get a copy of the CRP.
And copy ಕೊಡಿ.
Salman.
Yes. Password.
Jagadish, serial number petitioner.
I apply for the petition, my lordship. Kindly, today's time may be granted to comply the office objections, my lordship.
2 weeks time is granted to comply the office objection.
Serial number 7, Dinesh Kumar PM for petitioner.
Week's time is granted to comply the task. You complied, Mr. First.
Serial number 8, Narayan Bhatt M.
Week's time is granted to comply the task objection.
Serial number 9, Rahmatullah Kotwal for petitioner. Serial number 9,
Passover.
Serial number 10, Sri Ramana for petitioner. Sri Ramana Bhatti.
Which in the name of the deceased plaintiff, YF cost 30 and the CRP cost 30 shows as Veramma and Veramma were shown as a Irani Yamma in death certificate. Yes, what is this, Mr.? Who is-
Certificate has been given,
Who-
spelling mistake.
Who is that?
Original writing.
What is her name?
Her name is Kiran,
Iranamma.
but the Irani Yamma,
Yamma.
N has been, N-I, N-A will come, N-I they also. That is the objection.
Last night ಅಷ್ಟೇ ಹಾಕಿದ್ರೆ ಹೆಂಗ್ರಿ ಸಿನ್ಸ್ ಡೆಡ್ ಬೈ ಅಂತಂದ್ರೆ ಅವ್ರಿಗೆ ಅಡ್ರೆಸ್ ಇಲ್ವಾ
Yes, yes, Irani.
ಲೀಗಲ್ ಏರ್ ಯಾರೋ ಹಾಕಿದಿರಲ್ಲ ನೂರು ನಿಸಾಗ ಅಡ್ರೆಸ್ ಇಲ್ವಾ
ಅವ್ರ
why
ಮಗಳು
you are not mentioned in that last item?
Find this full content.
Elevation
Without
slip.
content is only-
ಹಾಕಿದಿರಾ
Yes.
yes ನೂರು ನಿಸಾ said so and so and so. Yes, Mr. Malipat.
I appear for the respondent. Caveator, my lord, the copy. That is Piranamma, my lord, alias Piranamma Darga. That is correct, my lord. But
Yes.
she is now no more. Her daughter is brought on record as LR. It is
Yes,
to
yes.
be, my lord.
No, office objection will be overruled.
Yes, my lord.
Submission of learned counsel for the petitioner is accepted. Office objection is overruled.
Copy.
Yes. Compliance of office objection number 1. What is that? Is there any other office objection?
Not.
Yes, I will serve a copy to that other side.
No, my lord.
You serve a copy, Mr.
Not served. But in this, they have filed caveat 2022.
This
Not mentioned in this. No caveat like that.
copy may be served on me.
A party council name ತೋರಿಸಿದಾರಲ್ರಿ serve a copy, Mr. Yes. You serve a copy next week.
Please, your lord.
Office objection is overruled. Thanks.
Number 11, H.V. Devaraju for
Okay.
petitioner.
Making of petition number 2 and the petition number 4 as a party, twice this petition and sign this same along with the council submission.
2 and 4 years. It is 15 and 13.
Petitioner number 2, Savita.
Savita, 4 also Savita.
Hmm.
That they have been in the parties that were put in the 13th independent and 15th independent.
Same party.
Same party. One side, one place he has described as a husband name, another place is a father name.
No, is it a different?
Same.
Why they have made it twice?
That they have, because of the RTC twice that there, her name is there.
RTC twice name ಇದ್ರೆ ಕಾಸ್ಟ್
That they have made it.
ಅದಕ್ಕೆ ಅವ್ರು ತಪ್ಪು ಮಾಡಿದಾರೆ ಅಂತ ನೀವು ಯಾಕೆ ತಪ್ಪು ಮಾಡ್ತೀರಾ?
Because that their party is there is independent, therefore I have.
The suit filed by the plaintiff.
Yes.
You are in a defendant.
Dependent 15 and 13 are one and the same.
ಆಯ್ತ್ರಿ ನೀವು ಒಬ್ರು ಒಂದ್ ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಸಾಕಲ್ಲ, ಇಬ್ರು ಹೆಸರು ಇದ್ರೇನು ಒಬ್ರು ಹೆಸರು ಇದ್ರೆ. Why you are making also same?
Because I have mentioned it well here that in the last itself. That is independent and 15 independent are one and the same.
ಆಯ್ತ್ರಿ ಒಬ್ಬರನ್ನೇ ಹಾಕಿದ್ರೆ ಸಾಕ್ತಾನೆ. ಒಂದ್ ಕೇಸಲ್ಲಿ ಒಬ್ರು ಪಾರ್ಟಿ ಮಾಡೋದು ಉದ್ದೇಶ ಏನು ಅಂತ ಅಂದ್ರೆ they know that intimation. You take out that one of that Savita.
I'll add it.
Yes. Correct it.
I'll add it.
Yes. Week's time is granted to comply that of subjection.
Number 12, Narajivaya KP for petitioner.
Yes.
dispensation of the respondent.
Awaiting service of notice to R1. What is the dispensation you want to? Dispensation of the notice to R2.
But they are not contested the parties in this. The petitioner clearly stated that the character of petition
What is that suit for?
suit for partition.
Who are you? You are a defendant.
And the one of the different.
What is that plaintiff obtained that interim order?
And then make an application for which is rejection of claim.
Does not disclose.
Rejection of is
Your IA is dismissed.
yes.
Then who are the plaintiff? Plaintiff
In
has
this case, and
plaintiff are right.
if Varun sir,
Have you made that plaintiff as a party?
yes,
Which respondent?
first one. Varun sir,
IA allow ಆಗಿದೆಯಾ?
yeah, dismiss it.
Huh?
ಎಲ್ಲರ
ಅಲ್ಲ ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ ಇಲ್ಲಿ?
dismissal of the order
Order 7?
rejection of claim.
Huh?
Rejection of claim.
Oh, then you are a plaintiff.
Yes,
Who has filed this application for rejection of?
I.
Huh? You are the plaintiff. You have filed an application for rejection.
No, I am the defendant over the suit.
That's what. What is your name?
Second question.
Hmm?
Second question.
Oh, that. There are two Sarva Mangalamma.
Yeah, one is
You are,
defendant, one is petitioner.
Now that, whom you want to dispense that notice?
From respondent number 2 to 10 soon. I am also sitting at 10 also. 9 and 10 also.
Already plaintiff name ಎಲ್ಲಿದ್ದಾರೆ ಸರ್ವ ಮಂಗಲ?
Here Sarvamangala is the plaintiff.
Huh?
Here Sarvamangala first petition is the petitioner. There are two Sarvamangala. One is
CS ಸರ್ವಮಂಗಲಂ ಎಲ್ಲ ಐತ್ರಿ?
in Swami.
ಪ್ಲೈಂಟಿಫ್ ಎಲ್ರಿ ಪಾರ್ಟಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲಪ್ಪ.
Our plaintiff is not more.
Huh?
There is dependency of
Now that LRs has been made as a party. Who are the LRs?
R1.
Huh?
R1.
R1.
Sagar is the
Varun Sagar.
yes.
Then others you want to dispense.
Yes. From R1 to 10 soon.
Yes. Learned counsel for the appellant has filed a memo seeking dispensation of notice to R2 to 10. Memo is taken on record. Notice to R2 to 10 is dispensed at the risk of appellant. Awaiting service of notice to R1.
I sent the copy to other set. These appear in current council.
They are not filed vakalasti.
For trial put the date.
Awaiting service of notice to R1. Yes.
Number 13, please take it down for petitioner.
Take leave, my lords. For the petitioner here, very minor objections, my lords, I shall comply it in the course of the day. The urgency, my lords, says a delivery warrant, my lords, could be issued
Yes,
today.
pass or you complain.
I do the needful.
Bill number 40, Kola Chambolingappa for petitioner, Nataraja Ekati.
Yes.
That injunction should withdraw that injunction since till principle that IA, since you will not extended to dispose of this to December.
Yes.
Till disposal of that IA, it will not be and I consider my application in view of that, this suit was but given forward may be disposed of, permitted to withdraw. And that
Now that what is the order you are challenging?
I am challenging about the order passed. It is says 569 of 2023, which 16.
Page
16.
60.
16. Relevant para is not at para 9, page number 20.
No, now you have filed an IA for clubbing that matter.
Allah, I clubbing the matter as this came to be rejected. As against that, this order came to pass. My respectful submission initially, I have my comprehensive injunction to. After bringing the.
No, I understood that you want to
Yes.
withdraw that.
Yes.
Now what is that you want to withdraw? This will become in.
Allah, infectious. The comprehensive symptom ಇಲ್ಲ ಆದ್ರೆ I injunction ಇದೆ ಕೊಟ್ಟಿಲ್ಲ
interim order ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಐಎ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಹೌದು. ಆ ಐಎ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ಡೈರೆಕ್ಷನ್ ಈ suit may be disposed of, forensic suit trial ಆಗ್ತದೆ. And then disposal of that suit.
Yes, Mr.
No, Lord, what happened is, initially this instituted a suit for bare injunction. Injunction came to be passed in their favor and later on vacated. And this article was passed in order, your lordship can see, page number 33. Where your lordship has given a status quo order.
No, that's what that, I understood that.
Later on, the Lord, day-to-day cross-examination has to happen. They did not appear before the court. I don't know why they have.
No, now they want to withdraw that.
No, if they are likely to withdraw the suit, then what would be the consequences of order passed with some court?
What is that order passed? That interim order?
Status quo ಮಾಡಿದ್ರೆ ಆ suit withdraw ಆದರೆ it amounts to
Status quo goes.
status quo.
Status quo goes. ಈಗ ಅವರು ಆ ಸೂಟ್ ಮುಗೀತು. Now he wants to file a suit for a declaration. For that he has to file a separate application for injunction. Application ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲಿ ನಮ್ಮ ಆರ್ಡರ್ ಇತ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವರು ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಮಾಡಿಲ್ಲ. Directed to consider. Till then status quo will be there. That's all. Now that is for the court to decide on merit, not on the.
If they are willing to withdraw the suit, OS numbers on their injunctions, I have no objection.
That's what that is taking. I will record
They
it.
should not come and say that no, we cannot withdraw because of some other consequences.
Now that is
Where's number 228 of 2023? 18 of 2023, that's suit for declaration.
2023.
Yes. Pending consideration before the number 30. I have not also pending.
Now I will record that you are going to withdraw that because that suit is not before me. Then I.
But both suits are before your last.
No, now you have filed an application in which suit?
I have filed application in this suit. The injunction suit not into your last.
That I understood, Mr. That is not before me now.
In the other suit, declaration suit application is pending.
Yes, now that anything can be passed only in that declaration suit. Other suit, because it is not before me, I will record your statement saying that you are going to withdraw.
Both suit are before your last because of installation petition, which is both matter. And that
You have filed an application in the declaration suit.
Yes.
Club that injunction suit in the declaration. Principal civil judgment active. Yes. Then I will say that suit is dismissed as withdrawn.
Yes.
Then this declaration suit can be continued in accordance with.
And
Yes, sir.
Yes, suit for declaration. The court had to take into consideration regarding the order passed with some.
Yes.
Now order ಮಾಡಿದ್ದಾರೆ status quo. ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ 39-1-2. ಮತ್ತೆ ರೀಎಜಿಟೇಟ್ ಆಗಬಾರ್ದು, ರೀಎಜುಡಿಕೇಶನ್ ಆಗಬಾರ್ದು ಆರ್ಡರ್ 39-1-2 because this on the court.
You want that declaration suit status has to be continued till disposal. You have no objection.
ಅದೇ ಆಗೋದು ನಾವು ಈಗ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ರಿ, ಅಬ್ಸರ್ವೇಷನ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
No, that can be continued. Then I can settle everything here. Yes, that is what that he wants. That I said that no, that is different. I can't decide that.
ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಕನ್ಸಲ್ಟ್ ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್.
That is what that I am asking. You yourself saying that it has to be.
Court may take that kind of ಇದನ್ನ ತಗೋಬಹುದು ಅಂತ ಅಷ್ಟೇ.
I want to clarify that without influencing my direction, they have to decide. But you yourself come forward and saying that therefore but is keeping quiet and watching everything that. I know that how that you have to be applied your mind before this thing. Court as itself is in your favor, it should be. Yes. This petition is filed by plaintiff. Section 115 of CPC. Challenging order dated 11th August 2023, passed by Principal City Civil and Session Judge Bangalore in miscellaneous number 565 of 2023. Filed under section 24 of CPC for clubbing YS number 3142 of 2022 and 2218 of 2023. Same came to be dismissed. The plaintiff has filed yes, YS number 2218 of 2023 for injunction. Later, he has filed comprehensive suit YS number 3142 of 20. First, filed an OS number 3142 of 2022 for injunction. Later, he has filed OS number 2218 of 2023 for declaration and injunction. Now that learned counsel for the plaintiff has submitted that since he submitted that he wants to prosecute comprehensive suit OS number 2218 of 2023 and he will not prosecute that OS number 3142 of 2022 and he wants to withdraw that. To that effect, he has also filed a memo before this court. The memo is taken on record. The OS number 3142 of 2022 pending before CCH 16. Here, ಯಾವ court ಅದು? Civil judge. City Civil Judge Bangalore is dismissed as withdrawn. And he may be permitted to prosecute that OS number 2218 of 2023. And he has also filed an IA under order 39 rule 1 and 2. Same is pending before 2218 of 2023 before so and so court. Portal number 13. Till that application has to be disposed of. The status quo to be maintained in respect of suit scheduled property by the both the parties. The trial court is directed to dispose of that application in accordance with law without influencing any order passed by this court in earlier MFA 5292 of 2022. Accordingly, this petition is disposed of. There again. 5292 of 2022 ತಾನೆ ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. Yes, without influencing that, let him pass an order after hearing that. Yes. Fourth respondent, you will take notice.
The trial court also dispensation was made.
Yes, notice memo ಕೊಡಿ. Learned counsel for. ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರಾ? 1 to 3. Filed a memo for dispensation of notice to R4. Memo is taken on record. Notice to R4 is dispensed. Yes.
Number 50, this is Sitaramana for appellant.
Appearing for appellant in this case, madam.
This objection ಇದೆ. ಮಂಡ್ಯ ಎಡಿಷನ್ ಅಂತ ತಗೊಂಡಿದ್ರು, ಬೆಂಗಳೂರು ಎಡಿಷನ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
My lord, I already taken a paper publication against the respondent number 1 in this case, my lord.
Respondent number 1.
Yes, my lord. Yes, my lord.
Respondent number 1 is in Mandya.
Mandya, sir. Yes.
How you are taken in that Bangalore edition?
No, my lord. It is Mandya edition, my lord. It is Mandya edition, my lord.
Really, really found it. Monday until a paper.
This is Bangalore edition.
My lord,
This is Bangalore edition. It is not Mandya.
my lord, I will verify it, my lord. Actually, my lord, it's
Bangalore
from the-
ಅಂತಾನೆ ಎಲ್ಲ ಕಡೆ ಬೆಂಗಳೂರು ಅಂತಾನೆ
mentioned as Monday, my lord, in notice page.
Yes, yes. As per that order dated 28/7/2023, appellant has taken notice to respondent number 1 by paper publication in Samyukta Karnataka, Kerala Daily newspaper. Along with that memo, he has enclosed the paper publication. Respondent number 1
Respondent number 1, Subramania.
called, none appear. Memo is accepted. Service of notice to R1 is held sufficient.
Serial number 15, again variant for appellant.
Yes.
One request, if my learned friend wishes to place lot of matters today in the morning.
We'll have it some other day, or we'll post it for hearing. What is that to be here? Yes. Oh, you have filed an application for vacating. Yes.
Before that date, on 7/8/2017, joint development agreement is accepted. And on 13/9/2019, approval is given. Because there are 272 apartments and a lot is of the apartments have entered into registered agreements to sell those allotments before the date of this. In this context, what I press forward, this entire suit is in respect of about 79 acres of land. The project in respect of which I am seeking relief is on 2 acres 32 gunnas. That if he succeeds, he will get about 24 gunnas of land. That is his claim in respect of the property lots where I am seeking. What I submitted was that I have also produced guidance value. One that created non report as of in respect of this. If we get about 23 gunnas, it's about 2.5 crores. If we were to succeed. I said also on the last occasion that there are 9 unsold apartments. The value of one apartment is about 90 lakhs. That is about 8.5 to 9. The landlord made a statement saying, I will keep those 9 apartments, I will not sell them. But let permission be granted to sell them immediately. Therefore, what will happen is there are third parties whose interests have been taken before the date of the suit.
Yes.
I have obtained loan. I have undertaken construction. Yes, I will be able to sell those third parties will not be affected. The plaintiff's rights will also be protected because about 9 apartments are about 9. I also.
So what is the suit for?
This is suit for partition.
No, just I'm not hearing that. I want to know that.
It is suit for partition.
Yes.
I'll read I'm the
Yes.
What has happened? There are five siblings. Property belonged to my great grandfather.
Yes.
My great grandfather, property, it was an Inam grant. Pursuant to the Inam Abolition Act, grant was made in the name of my father. But there was an alleged settlement deed which was executed by my grandmother in favor of my 2 brothers. So, on the basis of that alleged settlement deed, they are claiming that they are the owners of the property. in respect of the same lands, there is another suit filed. Not in respect of all the lands, but in respect of the lands in which my learned friend, Manu Putani, is interested. There was a suit filed. That suit for partition has been decreed. So that suit for partition is a decree. RFA is preferred by my learned, by Mr. Prakash Abbas time. And in that RFA, there is a say of drawing up of final decrees. One of the difficulty in granting the leave that my learned friend is asking is that if my lords were to pass some kind of an order, it affects the RFA, it affects the FD. Because there is already a partition suit, final decrees. Now, if he is allowed to sell, then he is creating so many multiple party interests. Now, currently also the situation, there are only 5 people. But when we see there are more than 40 different respondents,
Yes.
because of all the sale transactions and other things which have happened pursuant to 2004.
Now, what is the order which is challenged here?
The order which is challenged is the order of the trial. I had an advocate ex parte order that was negated by the order of the trial against which I came up. So when I came on appeal members, Mr. Hemar was not given. He gives notice even for Mr. Manupur and his claims.
Yes.
Thereafter, the interim order came to be passed. After hearing all of us, the interim order came to be passed. Matter was admitted for hearing. Matter is in fact stated down to be heard. Insofar as the answers and respondents are concerned, paper publication is already taken. After paper publication is taken, matter is stated to be heard on September 19th. For matter can be taken for final disposal on September. Now, insofar as Mr. Manupur and his claims are concerned, they were heard and only then an order came to be.
Yes, we'll hear that matter.
That's
Monday. Yes. Use this matter on Monday. Yes. Not found. Adrachi left. Adrachi left ಅಂತ ಬಂದಿದೆ. Yes. They are consented for the training. If you look to consented design, it's not the board and final now. They said that if they are taking notice and you are supporting that, you can engage some counsel for them and prosecute that, because service, unless service is completed. No, they can give a release date. Yes, let us see. Yes. Yes. Week's time is granted to do the needful. Yes.
Number 18, Karumaya TA for appellant.
Not below the cost title with regarding to that not arriving deceased or to yes. Yes. See? Yeah, page number 16. Six alien will L ಓದ್ತಾ ಇದ್ದೀರಾ? I didn't find that. Class title respondent number 2 deleted. Yes, yes, yes. What is that office objection now? What will regarding not arriving as a part? Yes. Submission of learned counsel for appellant is accepted. Office objection is overruled. What is this matter? Hmm. 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 Yes, issue notice. Yes, emergency.
Serial number 20, Ashwin Kumar MS for appellant, YK Narayana Sharma.
Yes. Non-compliance office objection was IA before the trial court to be filed to verify the scheduled details. Yes, you have to furnish that IA. What is that this thing? I file it in that office, we'll have it tomorrow. Tomorrow, yes. Monday. Yes. Weeks, what 2 days time is granted to comply this office objection. Leave this matter on Monday. You comply it by today.
Serial number 21, Saravana S for appellant.
Yes, leave this matter next week.
Serial number 22, Delhi for appellant, Ravi Shankar.
Yes, learned counsel for the appellant submits that needful has been done. Office to, yes, madam. What annexes? Furnish, yes. Yes. You are appearing. So learned counsel. What is your name? So learned counsel undertake to appear for respondent number 213. Office is directed to show her name. Yes, now that you serve a copy. Yes. Yes, post this matter for admission. Why? So that what has happened to that admission or the applied counsel surface act counsel contend that trial court has committed an error in conclusion that suit itself is not maintainable the collision temporary so and so. Next date of hearing. Corrective putting any further on EMI till the next date of hearing. Appellant counsel director serve a copy. You serve a copy. Post this matter of 4 weeks. Yes. Post this matter of 4 weeks. Interim order granted earlier is extended till next date of hearing. In the meantime, you serve a copy to them. Yes.
Serial number 23, Bharat K for appellant.
Yes. Council submission with regarding the copy subject. Yes, Mr. Password. Also.
Serial number 24, SP for petitioner.
Compliance of office objection. What is this? Yes. For records, review the judgment dated from RFA. What is this matter? Hmm. Who are you? You are not a party. Yes. Now that you amend that prayer. Effect of review is that you have to review that order and dismiss that petition. Dismiss that appeal. That should be your prayer. Second prayer is to dismiss. Yes. Yes, tomorrow. Yes, Pastor.
Number 25, we are forward for petitioner.
Yes. Steps to be taken in respect of unclaimed the respondent as per postal Sarah. Yes. No, you want time? Huh? Unclaimed ಅಂತ ಬಂದಿದೆ. Steps to be taken in respect of unclaimed the respondent. Who is that respondent?
Not claimed, return to sender. DS Srinath.
This is filed by whom? Wife has filed. What is that order you are challenging? For announcement. Maintenance granted petitioner change finance from 25 to 30,000 per month from date of this petition. Now you do one thing, you take hand summons. Tomorrow, see if the persons who are not actually interested will say that it is held sufficient. But as per that rule, non-claimed is not an this thing for. Tomorrow you may challenge that if you pass any final order, that will be the ground. Yes. Yes. Issue fresh notice to respondent in addition. The petitioner is permitted to take out hand summons to respondent. Serve it and then move it. ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ 10 ದಿನದ ಒಳಗಡೆ.
During interrogator application matter, serial number 26, P. Shetagiri Rao for petitioner, P. Raviraj.
Being a loss of deceased petitioner. Petitioner, who are the tellers? wife and sons. Yes. IA 1 of 2021 is filed for taking a loss of deceased petitioner. There is that affidavit for the reason stated in the accompanying affidavit. IA 1 of 2021 is allowed. A loss of deceased petitioner is permitted to come on record. Learned counsel for the petitioner is permitted to amend the custody. You amend it, madam? Yes. Then we'll proceed. Yes.
Serial number 27, Srikanth P for petitioner, Ramesh Babu.
Days delay in filing an appeal. Will condone it. Delay will condone. There is a delay of 14 days in filing an appeal. IA 1 of 2023 is filed for condonation of delay. Here is that affidavit. For the reason stated in the accompanying affidavit. Delay of 14 days in filing an appeal is condoned. IA 1 of 2023 is allowed. Yes. What is this matter? Our argue madly. He is the petitioner. Yes. Yes. You are the tenant. Ready to vacate? Opportunity ಕೇಳ್ತಿಲ್ಲ ಅವರು ಖಾಲಿ ಮಾಡ್ತೀನಿ ನಾನು ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. No, how many times, how many months you seek for an further time to vacate? ಏನಂತ? ಏನಂತ ಎಷ್ಟು ದಿನ ಟೈಮ್ ಕೊಟ್ಟಿದಾರ ಅಲ್ಲಿ? Yes, mister. ಏಜಿಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ ರೀ? ಏಜ್ ಆಧಾರ ನಂಗರ ಎವೆಕ್ಟ್ ಮಾಡ್ಸಂಗಿಲ್ವಾ? Why that all this let him close, then it's better. ಎಷ್ಟು ದಿನ ಟೈಮ್ ಬೇಕು ನಿಮಗೆ? ಯಾಕೆ 15 years ಬೇಡವಂತ್ರಿ? Now you have given undertaking. You take 1 or 2 months and vacate it, mister. That's all. Or you argue that I will dismiss it and execute them. Take 3 months time and vacate it. File an affidavit. Invest ಮಾಡಿದ್ರೆ 6 months ಆದ ತಕ್ಷಣ ಹೋಗಲ್ಲ ಅದು. It's saloon shop. It will be there for this thing. That cannot be, mister. You give an undertaking and vacate these premises 6 months. So 3 months. 3 months, mister. Yes. No, mister. No. I know. The property they have in a right, mister. Now it is a suit for ejectment. It is not that HRC petition. HRC petition that they have. That is not that law that they have to give a notice under that 106. Then you have taken evict. 4 months you file an affidavit. 4 months. Yes, when will you file? Tomorrow, Monday. Yes, Monday. Monday ವರೆಗೂ execute ಮಾಡಬೇಡಿ. Yes, Monday. Yes, please. 4 months. Yes. Yes, September, October, November, December. End of this year. Yes, end of this year. ಹೊಸ ವರ್ಷದಿಂದ ನೀವೇ ಶಾಪ್ ಓಪನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್. ಏನ್ 2 shops ಇದೆಯಾ? What about this? Same. Yes. 30 days delay in filing petition is condoned. 14 days. 14 days delay in filing is condoned. IA 1 of 2023 is allowed. Post this matter on Monday. Yes.
Number 20, Narendra Gowda, PP Jaykumar for appellant. V. Vaitappa.
Yes. IA in filing an LRs of appellant. Yes. Who are the LRs? IA 1 of 2023 is filed for condonation of delay in filing LR application for the reason stated in that accompanying affidavit. Delay in filing LR application is condoned. IA 1 of 2023 is allowed. Consequently, 2 of 2023 is allowed. The abatement is set aside. IA 3 of 2023 is allowed. LRs of deceased appellant is permitted to come on record. Why? Notice has to go then. Yes. Permitted to amend that constantly. Issue emergent notice on IA number 4 of 2023. Yes. Notice kalsi. Then we will see. Amendment madi.
Number 30, separate for appellant.
Yes. Filing that recalling application. Have you completed? Pending consideration of IA 1 and 2 of 2023. 2 weeks time is granted to complete.
Number 31, Manish for appellant.
Matters were listed the day before my lordship passed an order. We place that on record.
What is that order?
Matter, my lord, in my application for injunction, portion of the order.
Submitted that is connected matters. So it has granted.
One matter, although I moved it was not listed the day before.
Your order will not intended to put up any construction for. These are all connected matters. Yes.
One matter was restored the day before it got listed.
Yes. IA 1 of 2023 is allowed. Production of certified copies of the order is dispensed. Number
32, Manmohan P and for appellant.
24 days.
What is? Yes.
That's and one. First it is. IA number 1 of 33 and IA number for TA also IA number has to be changed. ಎರಡು ಐಗೂ I number 1 ಅಂತ.
Yes, sir. Yes.
Number 43, Karnataka for appellant.
Dispensation.
IA number 7 and IA number 7.
No relief is sought against R3 and R6 issue of notice to those respondent may be dispensed. You want to dispense?
Two respondents 3 to 52. One left,
Yes. IA 1 of 2023 is allowed. Production of certified copies. The order is dispensed. Issue notice. Learned Counsel for appellant has filed a memo seeking dispensation of notice to respondent number 3 to 62. Memo is taken on record. Notice to respondent number 3 to 62 is dispensed at the risk of the appellant. Issue emergent notice to 1 and 2. In addition, the appellant is permitted to serve appeal copy on counsel appearing for respondent number 1 and 2 before the trial court.
Sachin GS for appellant.
Notice.
Prashant VC for appellant.
Also,
Serial number 38, against petitioner, granted matter, yes, Manjunath.
Yes. Pass out.
also.
Tomorrow.
Not tomorrow, Monday.
Monday.
Yes. This is matter on Monday.
Party, petitioner, R.P. Sadashivappa.
Yes, Uday case. What is it? Yes. Suit for ejectment. What is the stage of suit now? Who is Uday KS? Whether now they are interested or let that suit may be disposed of. Why that CRP is pending? Who is that Uday KS? Passor. Passor, that let your colleague be present. Let us see. I don't think any order can be passed. Passor, let you ask her whether that you intimate that counsel for the petitioner.
Number 41 action. Serial number 42, Hiramakat Mahesh Sharian.
Is a dependent. Secret Miller. Your lordship, 20. Is that or policy possession under the present respondent number 1 Miller. Production of any document to show the general relationship between the petitioner and respondent. So the respondent number 1 admitted in the entire deposition, cross-examination, there is no records and other aspects.
No, are you saying that plaintiff is a owner?
Examination of the fact of the case is husband of the petitioner was a tenant under 1 Krishna. Husband of the petitioner was a tenant under 1 Krishna from 2013. Petitioner, respondent number 1 and 1 Krishna, all of them residing at very same premises till 2016. The respondent number 1, being aware about all those facts, she had purchased the property from Krishna. Position, she admitted that kindly come to the page number. Examination of the page number 93, last paragraph. Residing in the house opposite to the school scheduled property, the property consisting of the school scheduled properties are totally 8 residential houses. With the purchase of school scheduled property, tenants for the sharing of the 8 houses. After property, some tenants were changed and we had to settle their advances. The respondent number 1 who purchase of the property by assuring all the tenants, he will settle the lease amount. But all the houses are single bedroom. My house is a double bedroom. Thereafter, after purchasing of the property, the respondent number 1 started to bargain with my husband to vacate the property by receiving 5 lakhs. When my husband did not agree to the same, the respondent number 1 filed a police complaint before the jurisdiction police. Thereafter, my husband filed a suit in OS number 777 5,000 of 2016, my lord.
For what?
Obtained interim order against the present respondent number 1.
No, suit for what?
Suit for the injunction suit filed by my husband against the present respondent number 1. Decreed, my lord. Plus, mainly come to the page number 94, cross examination of the respondent.
No, where is that degree?
Yes, sir. Page number 67.
7.
Yes, sir.
Where is that order portion? Comment injection in favor of the defendant agent. In the judgment and degree passed.
Yes, my lord.
197.
Yes, my lord. Come to the page number 94. Cross examination of the respondent number 1. My lord. Second paragraph, it is true that there was a stay order in favor of the second defendant in OS number 7757 of 2016. It is true that in the month of December 2016, we had received the summons of the said suit. It is true that after receiving the notice of the said suit, I have issued a legal notice to the person. It is true that after that, January 2017, the present suit is filed. It is true that I have not stated anything about this said suit in the present suit. By suppressing the earlier proceedings, by suppressing relationship between my husband and the respondent number 1, she filed a present suit. My lord. There, what document produced by the respondent number 1 to show that I am tenant under respondent number 1? Take to the very next page, page number 95. First paragraph. It is true that there is no rent or lease agreement between me and the first defendant is petitioner before your lordship, my lord.
Yes.
Second defendant is my husband. He voluntarily come on record in suit proceedings, my lord. After obtaining the he come on record voluntarily. The respondent number 1 not seeking any relief against my husband. Suppressing the rental agreement and the lease agreement with the one Krishna, only she filed a suit against me by suppressing all those facts. She herself stated that it is true that there is no rental lease agreement between me and it is possible to suggest that I have the knowledge that the second defendant is a lease under the earlier owner of Krishna.
Krishna is your husband?
No, my lord. Owner of the property. Krishna is owner of the property. My husband, I am not a tenant under either Krishna or present respondent number 1. My husband is a tenant under one Krishna from 2013. My lord. I have produced the document.
No, you are residing in that property.
Yes, my lord.
You are not disputing that plaintiff is the owner.
Yes, my lord.
Then what capacity you are residing in it house?
My lord, at the time of purchasing the property, the respondent number 1 herself committed that she will settle the lease amount of my husband.
Therefore, you are saying that you are a tenant.
Yes, my lord.
You want to lease a amount.
But my lord, to file any suit against me, she has to produce the jural relationship with me.
No,
There
that
is no jural
no.
relationship.
See, if you are admitted that plaintiff is the owner of the property, then it is for you to. Then plaintiff said that you are the tenant. Then it is for you to show that you are not tenant and what capacity you are residing, whether as a mortgagee or lessee. That is what this court said.
But my document is there, my lord. Document is there.
No, what is that capacity you are residing in this house, Mr.?
Yes. The annexure B.
You are saying that lease.
Yes, sir.
What is the lease? $11 months notice, 11 months lease. Other tenancy, ideal.
Therefore, it has been extended to time to time.
Aye. Notice ಕೊಟ್ಟು event ಮಾಡಿದ್ದಾರೆ. What is there in that?
Without issuing any assignment notice to my husband, my lord. Without made my husband as party in the present suit. Without saying anything about the pending suit between my husband and respondent number 1, my lord. Suppressing the intention order granted in favor of my husband. She filed a present suit against me. Without producing any records, without producing any lease agreement, rental receipts, anything. She filed a suit against me.
Yes, you take out notice.
Now, she filed thereafter, after passing the order by the trial court, she stated that matter settled. That is the reason we did not move the CRP till now. All of a sudden, after lapse of 1 year, now she filed an execution petition. The order itself is currently into the rear of the petition, respondent number 1 in the.
Are you paying that rent regularly?
Lease amount is there, 12 lakhs lease amount is there.
Lease amount 12 lakhs ಅಲ್ಲಿ ಏನಂತಿದೆ? Is it
Yes, madam.
where is that lease? No rent till that
Connection fees is agreement.
connection
fee. The respondent number 1 herself stated that in the cross examination, after the purchase of the property, she said
that lease is between you and that your husband and the Krishna.
Yes, madam.
Yes.
And in prayer, entire prayer, she never sought any relief on the damages or rent, but the court passed on entire order, my lord. Rent ಗೆ damages ಗೆ ಎಲ್ಲದಕ್ಕೂ order passed
Issue
ಮಾಡಿದೆ.
notice. They are further proceedings in execution petition
Execution number, my lord.
file along with that memo, Mr.
Yes, yes, madam.
Execution number ಕೊಡಿ. Yes. They have further proceedings in execution number so and so till next date of.
Number 43 is done. Number 44, Sudhindra essay for petitioner, Parshurama Rattar Kyal.
Respondent number 5, my lord, the copy is not been served and the meeting is into the copy.
Respondent number?
5.
Respondent number 5.
Including the review petition. And it was
Necessary parties this petition is. Office objection. For this matter, increment next date of hearing. Yes, notice is not yet issued. The petition is disposed of. Now you want to take notice for respondent.
petition is converted, it's not disclosed. Converted and disposed of.
What is your client name, madam? You want to take notice? Yes, so and so is undertaken to appear for. So and so has filed an wakalat for respondent number 5. Office is direct to show her name. Yes, we did.
Both of them can take notice.
For them to decide if they don't want to take notice. Yes, you want to take notice for an. Now, what is this matter? What is this matter? Yes, Mr.
A compromise petition was filed. Alleging that the fraud has administered in getting the compromise. An application filed for recalling the order regarding the compromise. So in the first instance, the civil court allowed the application. But pending inquiry. So that was challenged before the Honorable Court. The Honorable Court held. See, unless the inquiry is held, you cannot IA is. Thereafter, inquiry was conducted. After inquiry, the trial court has allowed dismissed higher number 8, holding that compromise is in accordance. That order has been challenged before the Supreme. There is an interim order of stay. So this matter requires a reappreciation of the whole evidence.
Yes.
This
So that you will complete that process of service. You are taking notice to whom, Mr. 1 and 4.
1 to 4.
1 to 4. Then you are appearing for 5 and 6. You take notice to 6. 6 you take process. Yes. So and so, aviator is undertaken to appear for respondent number 1 to 4. so and so learned counsel undertake to appear for respondent number 5. Issue emergent notice to respondent number 6. Yes. And also you take hand summons. In addition, the petitioner is permitted to take out hand summons to respondent number 6. Leave this matter immediately after service of.
We will, sir,
Serve a copy.
All of
Interim
them
order
are
granted.
protested for not in interest. They are husband and wife and the mother-in-law of the petitioner, first petitioner. All of them are promoted each other and protest my petition. They all are supporting that.
Let us see that we can't hold them to yes.
Let
Interim order granted earlier.
Immediately.
Yes, immediately after service.
Please.
Yes. Interim order granted earlier.
Otherwise, it is not listed. Any tenth member, any date may fix more.
No, that let them serve first.
No, he is here only. Before the court only has appeared more. This one number 6 here only.
Yes. Post immediately after service. Yes.
Please help me with the urgency. Second round litigation is there. Already 10 years ago, suffered. They are enjoying the rents more than 3 lakhs rupees per month.
Yes. Reach this matter on 20th.
Date is more 15th or 16th. 20th of September.
Yes.
20th.
16th ಇಲ್ಲ 16th ಎಲ್ಲ ರಜಾ ಇದೆ ಅಲ್ರಿ 18th ವರೆಗೂ 19th. Yes. Yes.
45 Kantaraj petitioner.
Kantaraj T.
Here, please find it in the out of 7 rule 11 menu. So, predicting evidence from a the defendants from the balance inventory of a land. Totally where the scheduled property belongs to the home. So, the what's under in the order, nothing is mentioned about the territorial jurisdiction member. Now we come to page number 23. Where they have not said anything about the
What ground you have filed an application?
I filed some basically. One is the territorial jurisdiction, other one is the RERA provision. Because the builder has not followed the RERA provisions and has not provided the amenities as he has promised in his brochure and then the videos and the advertisements. So these defendants in fact asked him and then sent a letter, sent a reminder, sent legal notice for which he has not replied anything, and then directly he has come and filed the suit before civil court. And there is no jurisdiction of the court. So because this falls under Bangalore rule of courts.
Yes. What is the finding of the trial court?
Kind of the trial court says this is not coming under RERA jurisdiction, but it does not mention anything about territorial jurisdiction. Silent on both, even the plaintiff did not say anything about the territorial jurisdiction in his objections, and then even also this court has not said anything about
Why it is not coming within the
no, my lord. I got the RTA also today. It says that it is not coming under this.
Where is your application under order 7 rule 11?
Page number 34, my lord.
Yes. Where is your ground?
Page number 39, my lord. That
Yes.
even with overlooking the RERA Act of 2016, this honorable court does not have the territorial jurisdiction to try the above suit as the schedule A and B property is situated in Uttarali OB and the same comes under Bangalore rural district. Hence, this court does not have the territorial jurisdiction to file the above case in hand.
What is the finding regarding that?
Nothing, my lord. Like they mentioned twice, but nothing has been said.
Page number 26 in the first.
Yes. Issue notice. Yeah, further
They are
proceedings.
proceedings. In the
YS number 3924 of 2022 till next date of hearing. Yes. Stay up for the
Stay.
session. Sorry.
Till next.
Number 46, report of serial number 47, Nagaraj Rao case for appointment. Hindu Shekhar.
Yes. Yes.
ನಮಗ್ ಕಾಪಿ ಇದುವರೆಗೂ ಕೊಟ್ಟಿಲ್ಲ ಕಾಯಿಸ್ಬಿಟ್ರು ಯಜಮಾನ್ರು.
Yes, what is this matter? Just.
The battery correcting factory. Battery correcting out of the category proceedings.
Yes.
And the respondent will be kindly. All right, I should get it. Please run.
No, you point out when you are giving in a reply. That's it. No, you point out all this when you are giving in a reply. Let him argue, then you reply. If you satisfy this quote, then I will dismiss it. Yes, you wait for that reply. Let him complete this.
I'm referring to page mentioned here.
Yes.
Let me go to page 25.
Yes.
Consequently, the parties representing the directed mentioning. Item 13 and that right, 13 of the property until it. I thought we have the registered partition, I have read the registered partition has been upheld in partition.
Yes.
Could not should make directly go to.
Where is that
Page,
preliminary degree?
right, and just tell you, could not should make go to 42, page 42.
Yes. Yes.
That is issue number 7, whether the plaintiff is entitled for a relief of declare that the partition or settlement is dated 27/3/1972 is reflecting on the parties to the issue. The issue is on the plaintiff. Lordship is releasing in negative. That means partition has been upheld.
Yes.
Then the lordship can kindly go to reasoning at page 51.
Page 51.
Page 51. Your lordship will be the plaintiff has not challenged the partition deed, your lordship.
Yes.
Not the IRC claim.
Yes.
The plaintiff has not challenged the partition deed and has still offered to develop the primary DNA. The partition is and they were visited the independent. Let them go to read or grant from the partition remaining property direct to the. The remaining property direct the partition deed acted upon the. And also during lifetime of the father, you will come to 1999 and not challenge these. Since 1970-71, hence the dependent dated. Eastern partition is binding on. Okay, and other property item 98 dependent by purchase to the and also. control bunk, rice mill and mill tea house. Under these circumstances, 90 is not in possession. Accordingly, they are no right and right tightly interest. Mr. Chair, as their father died in 1999 and they cannot become co-person. That's the question is, there's a partition. That is, Amendment Act came into force, so that is in the prior to the amendment, that is in 1970, but 40 years back. After the 40 years, they felt as
Yes.
court has upheld the partition. I am constructing my building in my own property. I have to do the layout president of the photograph report. The honorable court, a 3-floor building is already completed. In fact, I have placed the photograph to the trial court also. But I am taking copy of the photograph also.
Now that, where is that plan and this thing?
I don't need to. Third is not completed. Not going to complete. Only question is only shutters have and internal walls. And that will leave them. Remember, it was a plan, it was granted in 2018. Then, almost recently is completed. And building license also on the next page. The construction. Right. Therefore, I have received the constants, I said, if you lordship that I went according to the effect every day. I do the matter that in a condition to in our way. I'm not claiming if it is it is true, so the building may be able to be completed and leased out, subject to accounting, subject to result of RFP.
This license period is expired.
The construction is almost completed.
No,
Just
see-
the rolling shutters.
ಪರಾವನಿಗೆ ಅವಧಿ ದಿನಾಂಕ 33/2019 29/3/2021 ಮಾತ್ರ ಅನ್ವಯಿಸ್ತದೆ. ಯು ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್ ಎಕ್ಸ್ಟೆನ್ಷನ್. itself it is expired.
Almost completed. In fact, my client has attorney has obtained extension. And point
No,
out.
see, when I am permitted you to continue, even that subject to result and all,
Right.
that should be legally. Otherwise,
Right.
my directions you can construct without the license.
Yes, I am not put it that.
Yes, you just very.
Take to the review panel.
Yes.
I have it on, push that witness.
Yes, read this matter next Thursday.
Just,
Yes. You serve a copy in advance also. Let him see that.
that's something of them.
Because I have noticed, they are not noticed. Otherwise, this is what, if you serve, see, in fact, that other side has to point it out. By this thing, I have noticed. No, you have also not noticed. He is also not noticed. Therefore, I said service in advance.
And such a copy in advance.
Yes.
Number 48, Kiran P.S. for appellant, Prabha Bhavikatti.
My lord, in this case, appear on behalf of the respondent, my lord.
Yes.
Your lordship,
But we filed this appeal.
Yes.
one humble submission, my lord, may be kindly passed to take in the afternoon session, my lord.
So she wants.
Afternoon session, my lord.
Our third matter in the afternoon, so it will be adjourned.
Next week. Yes. At the request of parties, release this matter. Next Thursday.
Please, my lord, oblige.
Number 49, Santosh Gudi for appellant, P. Srinivas.
Yes.
So my lord, I appear for respondent number 1 to 5. I undertake to file wakalas for 1 to 5.
Yes. Yes. Yes.
My lord, I request for a week's time to file objections. The MFA have not filed objections to the present matter.
He wants time. Is there any objection? Huh?
Regulate protection order, super specific.
Yes,
Agreement is admitted.
suit for specific.
Specific.
You are the plaintiff.
I'm
Your application for 39, 1 and 2
one
rejected.
and two rejected.
Why?
Initially, my lord, I had a benefit of entry.
Why it is rejected?
It is rejected. Then I conceded. I myself was not aware about my lord's accusation. My lord's interest. No one is shedding one is concerned. When my lord's accusation, my lord, I'm entitled for consideration. Even as my lord's led back to the Supreme Court, my lord's yes. Second, my lord's, there was earlier agreement with my lord's some other person.
Yes.
In my agreement, he has been shown. as a
Mr. Counsel,
Yes, my lord.
don't create third party interest.
That's all.
My lord, kindly the pattern will pass over 3 o'clock, my lord. Seniors engaged the total 1 before, my lord. He'll come and argue, please, my lord.
Pass over.
Pass over. 3 o'clock.
$50 Monday. Leave this matter on Monday.
Correspondent to be and
Yes.
so
Yes, pass over.
Senior is really
Pass over.
there is some urgency, serious urgency there. Kindly pass on senior.
No, let us see that you are an cavator. If there is any urgency, I have to protect. There is no cavator cannot be asked for a time. If there is an urgency, you should be ready for
Construction has been disrupted. by
once
virtue of
pass
the
over can be
order.
granted. Yes,
Kindly pass over.
that we'll see that. If we are not make out in a case, there is no interim orders. Only if it is there is an urgency. Yes. See that.
Number 53, page leader.
Yes, leave this matter next week.
Number 51, authority.
Yes.
54.
Hmm.
Yeah, number is not very, one is not very. Property allotted to the
Suit for
declaration and permanent injunction. Again, that is the owner and cancellation of the safety of the dependent number 2. That the property allotted to the opponent number
You are
1.
plaintiff for a defendant.
Plaintiff. Both applications are similar. Like, the GPA holder, the first dependent, both property item number 1 and 2 allotted by the society, the husband and wife, it is the apparent. 992 the sale. For the in order to sell the property, executed the GPA in favor of the dependent number 1. For searching the new buyer, purchase the property. He has sold the property in his wife name. Two sales. Husband and wife the properties. He has sold the property to his wife without notice to the parents.
No, you have given a GPA
Yes, the GPA has been given.
with consideration.
No consideration, only selling power has been given. Not receiving any consideration, there is no sale agreement, there is no any amount received from the first dependent.
Yes.
He has sold, created the sale in his own wife name. Without knowledge, without.
Why you have given GPA?
He is a close relative, family member. They are in Rajasthan, the appellants. Thereafter they are settled in Bangalore.
Yes.
On the strength of the GPA has created sale without notice to the petitioner. Thereafter, after.
Oh, what is that application you have filed?
Right.
Interfering with the possession because they are already in that possession.
We have paid the property tax and the current water bill and the power bill. And we have produced the photos of the properties. The till date, The properties are the still retained property, man.
Yes, you maintain status quo.
They got the title portion, man. They got the title portion in both of its, man. One is not in repair, another is.
Maintain status quo.
Status quo, they got the title portion.
Status quo in respect of that property, it includes everything.
Yes, yes.
Issue notice. Parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing.
Unconnected appeal to the next one.
Same.
54 and 55.
Same order.
The order of remand is actually
Yes.
minor has been filed.
Yes.
Declaration of ownership and for my injunction.
Declaration and injunction. Hmm.
The food property manner that was shown in the plate was minor. Page number 40 minor of the agreement.
Yes.
Square gas and it's available 130 for 5. Measuring 28 food gas. And minor only minor that has been mentioned. The pattern remains. If the trial court dismiss this.
Yes.
And it dismissed this would stating that there is no encroachment that has been made of the parcel. But between so it is the plaintiff who has sold a portion of the property in favor of the defendant.
Yes.
Between the property of the defendant plaintiff, there is a road also.
Yes.
And hence there is no encroachment manner is the reason that was given. If it is
Yes.
against which manner he came to the fight. There were 2 applications were filed by the plaintiff. One is seeking the amendment of the plaintiff.
Yes.
Another manner is for production of the additional document. By seeking the amendment manner, the entire schedule was sought to be changed.
Yes.
They just pass on manner the amendment. What we want to say, my lord, now is at page number 3 of the amendment application. And you see paragraph number 6 and 7.
Yes.
ಭಾವಾಪತ್ರದ 4ನೇ ಶಿರೋನಾಮೆ 3ನೇ ಸಾಲಿನಲ್ಲಿ 28 ಗುಂಟೆ ಎಂದು ಇರುವುದನ್ನು ಹೊಡೆದು ಹಾಕಿ ಆ ಜಾಗದಲ್ಲಿ 3 ಗುಂಟೆ ಎಂದು ಸೇರಿಸಲು ದಾವಾಪತ್ರದಲ್ಲಿ 4ನೇ ಪುಟದಲ್ಲಿ ಅನುಸೂಚಿಯ ಚಕಮಂದಿಯಲ್ಲಿ 4 ಗುಂಟೆ
You are giving changing entire boundaries.
change.
Let him complete. I'm just expressing my reason. What is that order passed by that first appellate court?
First appellate court the order itself would allow the amendment application. Allows the application for production of additional documents without discussing what are the documents and how it is necessary for the adjudication of the matter. It reminds the matter to reply.
Yes.
I understand whether the application being considered at the final hearing stage, but the application will have to be dealt first. Thereafter, my lord, I will be having the remedies.
Yes.
Now, under the order itself, my lord, the appellate court would allow both the application. But the reasoning part, my lord, would commence from page number 15 of the agreement.
Yes.
Internal page number 8.
Yes.
It's a very short judgment running to 4 pages only. And may I read them?
Yes.
The plaintiff has filed a present for relief of declaration to declare that he is the absolute owner in possession and enjoyment of property, and also for mandate the injunction to direct the defendant to vacate and hand over the encroached portion of to an extent of 10 feet into 40 feet on the northern side of the scheduled property. The appellant being agreed by the judgment in of the trial court has prepared an appeal before this court and also filed an application under order to 26. When this court to permit the plaintiff to amend the claim as stated and in pursuit, the learned counsel for the appellant has ultimately argued that plaintiff is the absolute owner in his possession and enjoyment of the property. And he got the same by issue of registered sale dated 5/2010. Land in survey number 113. It also belongs to the authority. He has converted the same for the purpose of formation of site and accordingly has sold one site in favor of dependent and other three. Dependent while constructing the house, she has encroached nearly 40 feet in 30.5. The other has approached PMC to direct the dependent to vacate and hand over the encroached portion. And accordingly, they have issued an endorsement directing the plaintiff to approach this building. The plaintiff and his family members have partitioned the family properties under the registered partition dated 23/10/2008. And accordingly, 334 guntas was allotted to the share of the. As it is just and necessary to provide an opportunity to the plaintiff to put forth his case and to amend the pleadings. On these grounds, the learned counsel for the appellant prays to allow the appeal and remind the matter to the court for fresh discussion. On the other hand, Sri Aldia, advocate, has vehemently argued that in spite of sufficient opportunity, he has failed to produce the cogent, oral, and documentary evidence before the trial court. In the trial court, after appreciating all the records available before the court, and after appreciating the commissioner's report, has rightly come to the conclusion that the plaintiff has failed to do its title and also position of the property. The proposed amendment is nothing but more than the original claim. The plaintiff has not made up grounds to allow the application. On these grounds, Sri RDR advocate prays to dismiss the appeal. It is the contention of the defendant that as per the approved plan, the defendant has constructed the house in which is from the plaintiff, and there was no improvement as claimed by the plaintiff. On the reason of exhibit P1, it is clear that on the northern side of the boundary mentioned as the property of the plaintiff, the boundaries in exhibit P1 clearly indicates that on the northern side of the defendant property, there exists property belonging to the plaintiff. On the reason of the judgment of the trial court has come to the conclusion that the plaintiff has claimed the title over the land bearing 113 bar 5, measuring 30 meters, but the plaintiff has produced the document only with respect to 20 feet. Further, it is important to note that the defendant has not at all denied the title of the plaintiff over the two scheduled property. As such, the proposed amendment is very much necessary to elucidate the dispute between the parties. And we spoke about cases and contentions of the parties. Abruptly, in a single line, came to the conclusion that the amendment is necessary without discussing the nature of the amendment. Yes. Then next page, point number 2, the plaintiff has filed IA number 3 under Order 41/27 CPC. Begs court to permit the appellant to produce the additional evidence before the trial court. On perusal of the documents relied by the plaintiff, it is very clear that in order to adjudicate the dispute between the parties, the production of additional evidence is very much essential. Therefore, in the ends of justice, it is just necessary to provide an opportunity to plaintiff to produce the additional evidence. Which are those documents? How are those relevant for the adjudication? Nothing is there. In a single line, he allows the amendment application and he allows the additional production of the additional documents. And remands the matter. Such a remand cannot be made. In fact, the circular has also been issued by the court. Casual manner, such a remand.
Yes. Yes.
Then, one more thing is, survey number 113/5. And the adjacent property 113/4, measuring 4 gunta, 5 gunta. It is not the plaintiff has got conversion of the property and of course it is dependent also one of the purchaser of the land. In fact, not in the boundary towards the northern side, my convenience is towards the northern side. Okay. Yes. Of this is different. The property also originally belongs to me, right from the both sides, and both are from both sides. And this dependent, instead of constructing house in her property, measuring 40 feet into 27 feet, she has constructed in 37 feet into 40 feet.
Yes.
And by exposing the main side, that is the intention.
Yes.
But by that time, put northern side, since that was also my property, it is mentioned as property belongs to client, to
Yes.
Arnhem side.
Yes.
In fact, it was told to the related country.
Yes.
That's why the amendment was required, and the amendment application was read during the appellate stage. By considering all this fact, not the appellate court, waiting until the conclusion and remanded the matter. Moreover, there is no dispute with regard to the ownership of the property, and it is required
There are three
for
things.
determination of
There is no proper reason given for amendment. Second, out of 41 rule 27 says only in the specific circumstances that your additional documents can be allowed. There is no discussion.
additional documents are
Third is power to remand is very limited. Under 41 rule 23, the power is very limited. If that appellate court requires the additional evidence, they can take an additional evidence and dispose of. It is not that trial court has spent 5 years. The appellate court in one word has set aside and remitted back.
the additional documents are in support of the amendment. Not in IN 42. Not that is the subsequent development taking place. Not any other document. All are registered documents. We consider that we will not apply to allow the application. We
See, how it is wrong that earlier suit which has been dismissed, finding given that,
will also make really appreciate the
see,
binding.
now that property according to you has been reduced. Now that suit for declaration, whether it is a larger extent or a smaller extent, your title has to be proved. That you have failed to prove.
The observation.
By reducing that, how can that you get?
Page number 30, page number 30 after number
Yes.
there are 10.
Page number?
30.
Yes.
There are 10.
Yes.
It is relevant to note that the scientific.
There are 10 in which?
Not a transport bill.
Yes.
There are 10.
Yes.
It's relevant to note that the scientific seeking declaration of title and permission mentioned in respect of 28 acres of land as permitted by this council. The painting has showed some portion of the land, but we have not chosen to get the schedule amended. As such, this court is of the opinion that when the plaintiff has already disposed of some portion of the land, he cannot be declared owner of entire 28 acres and he cannot be said to be in possession of said land. The plaintiff ought to have got the plain schedule amended and sought the relief only in respect of property in his possession and possession. Not this. It was inevitable for the.
No, why you have to claim that declaration, the property which is not belongs to you?
Not it is subsequent development, subsequent development. Was by the year 2012. It does have not this development taken place. A portion has been sold and family partition taken place in the family of 19.
Then you could have sought for an amendment.
To the notice of the court when the time was going. They are not, it is not going to affect the dependent property. If at all he has purchased the constructed the house in this property, it is not going to affect him. And there is no dispute with regard to the property of the plaintiff. They are not disputed my title.
Yes.
These are all the subsequent development taking place during the pendency of the court.
Now that new scheduled is within that this thing.
Yes, not. Yes, exposed 10 by 40 feet belongs to me.
Yes.
And the boundary plot, the adjacent property plot in which I form the four sides and sold one of the sides to the defendant. He has encroached the 10 by 40 feet and for the removal of the 10 by plot I felt this too. And even the court commissioner also observed the encroachment. In fact, not there was.
No, what about that issue number 2?
With regard to amendment plot.
No, but the trial court has answered issue number 2.
Yes.
What is that?
Whether the plaintiff proves that the defendant has to be legal. Yes, no. For this law.
This is negative.
The plaintiff has made an application for appointment of a commissioner. Order 29. Not the prayer sought in the IJ bar to conduct a measurement and encroachment in the fruits of property. Whereas the report is in respect of the belongs to the defendant. In which also not court will not fight the same thing. Encroachment is there. But not it is the in the prayer it was thought for survey in social property, whereas the import commissioner has conducted the survey in the property of the defendant. That is the finding of the
No, if that would be the case, of first appellate court can reappreciate that evidence and decide why that matter has to be remitted back.
The matter is remanded back to the trial court for carrying out the necessary amendment along with the additional documents also. The same thing will come. Typically, in the proper not the trial court, even in the trial before the trial court, was not have given a report in the scope of the property belongs to the defendant. But the OAR to conduct the measurement and submit a report in the scope of the social property belongs to the plaintiff.
Yes.
Even if it is remanded back also, amendment is carried out and additional documents are produced, no way it is going to affect it.
Why matter has been sent it back, Mr. That could have been decided by the first appellate court.
To reappreciate the reading and also the document.
That can be done by the first appellate court. Now the finding given that second issue, he is set aside now.
The first appellate court, in its discretionary power, has remanded the matter.
There is no such discretionary power. You see that? No, that can be allowed, but not to be remanded as usual course. That is what that repeatedly that the Supreme Court as well as this court has held. When the evidence is available, first appellate court itself has reappreciated that. They could have been done. What is that answer to that issue number 2? Yes, let that application be. No, that now that amendment may be allowed. Additional documents can be taken that we may be permitted to adduce that evidence by the first appellate court. No, that two things. See, two things. The very same property, portion of the property he has sold. Now he has to reduce that schedule. That's not. It is not in a different property. If he wants to reduce that, whatever that property sold during that pendency, that has been, that documents he has filed under Order 41 Rule 27. It is covered under the subsequent events.
Try to meet by an additional return statement to the amended application.
No, Order 41 Rule 27 has been considered after your objection.
This is not the reason what I am saying. At least the court must say exactly documents that have been produced. I think for in spite of exercise of due diligence should not have been produced. I see that the ingredients of Order 41 Rule 27.
Yes.
That's the application is done. Now, the same manner in a single paragraph without even looking into what are the documents that are sought to be produced. Not in manner in consonance with 41 Rule.
Then again, he will consider and pass an order. It is nothing but a delaying that process. Is it not? See, if that application is not covered under Order 41 Rule 27, it is a different. Now that it is a subsequent event that can be brought to notice under Order 41 Rule 27. Either you want to go before the trial court or the first appellate court. Let the trial court decide after giving an opportunity. You can file an additional written statement if you want. First appellate court itself also can adduce that evidence and decide. Yes. What do you
This past. Paragraph number 11.
Yes. Justice Kumar or judgment. Yes, yes, we have that reported judgment. Yes, which is the paragraph? Yes.
An appeal is a continuation of original proceeding.
Yes.
In effect, the entire proceedings are before the appellate court and it has the power to reappreciate the evidence. It has the power to amend the pleadings, frame issues, resettle issues, delete issues, receive evidence by way of additional evidence. Court evidence, summon witnesses, and call for commission, pass. Take note of subsequent. Addition to the power of the trial court, it has the power of the mind. Power to set aside, modify, reverse, and affirm the judgment of the trial court. Also has the power to implement and lead to a party to the proceedings. Set aside the findings recorded against. Thus, the power of the first appellate court is unlimited. The reason being that it should be able to meet any contingency or situation and pronounce judgment finally in order to complete justice to the parties. Cannot plead or feel helpless to meet any situation arising in the case to resolve the dispute between the parties. That is the ambit and scope of the jurisdiction of the first appellate. Therefore, the legislature has entrusted a very important duty to the first appellate. It is for the court to decide finally all question of fact on which the disposal of this might depend. The order retrial of a case is a serious matter and may need considerable waste of public time. An order of remand should not be taken as a matter of course. The order of remand should be sparingly exercised. The endeavor should be to dispose of the case finally by the first appellate court itself. When the trial court, after considering the evidence, has come to a conclusion that the appellate court should not ordinarily remand the case, it should see first whether it can dispose of the case itself under Order 41, 24 to 27 CPC. Only if it is not possible to do so, and it is necessary in the interest of justice to remit the suit, remand should be restored. When additional evidence is tendered in the plea, the court should act under Rule 28 and not remand the whole case under this rule. Such an order can be passed only in exceptional case, as for example, where there has been no real trial of the dispute and no complete or effectual adjudication of the proceeding, and the complaining has suffered material prejudice on the account. Remand is not meant to provide stretch opportunity to a party to complain. Order of remand should be made only if the finding of the lower court is reversed in appeal. Where there is no reversal of the finding, the appellate court cannot proceed under this rule and remand the case for a fresh inquiry of the law. The finding is necessary on the point, not dealt with in the judgment, or that the inquiry has been inadequate. A remand for the purpose of producing fresh evidence to explain the evidence on record, where it was unambiguous or to cover up deficiency or to fill in gaps, is not warranted by this. If an issue can be decided by the appellate court on acquitted facts, the empty formality of remand must be eschewed to advance the process. Unfortunately, the first appellate court are not appreciating these statutory provisions in proper perspective. Though the first appellate court are vested with unlimited power, greater the power, greater should be the care and caution which should be exercised by the appellate court in exercise of that power. Especially the power of remand should be exercised sparingly and in rare cases. An unjustified remand is tantamount to an application of duty by the first appellate court to decide the case on merits finally. When the trial court are overburdened with the cases, the first appellate court, which are better placed and presided over by judges with greater experience, should take upon themselves the responsibility of recording evidence and decide the case on merits, thus shortening the length of the litigation. That is the need of the hour. Today, the litigant, the society, and the judicial system cannot afford the luxury of the order of the time. Therefore, it is impressed upon the first appellate courts that they should be doing a great service in the course of fight against delay in disposal of the cases by accepting the challenge, exercise their appellate power judiciously, receive and record additional evidence, and decide the case finally. They should avoid this temptation of remand on some pretext or the other. They should demonstrate their resolve to shoulder responsibility and commit in rendering justice to the litigant, who is knocking at the doors of the temple of justice patiently in anticipation of a judge. Judges should decide the rest. This would be one of the ways of not only reducing but also avoiding pocket within the existing legal framework. The reversing of the finding, my lord, is important. Is what we are looking for. It is not reversed.
In the appeal, the evidence was produced. The lordship will very appreciate this. The additional evidence is entered in the appeal. The court should act under proof in case, not remand the whole case under this proof. There's a difference between the principal right on that case and the present case.
What is that? No, first appellate court itself can adduce the record of evidence. That's what.
Now, already we made it. Already matter. Here for the court conduct, where you call.
Sir, evidence is not.
If the permission is given to me to tender evidence before the first appellate court, also no issue.
See, again, there is one more chance of appeal will be arises. That's what that this court said. Again, it is in a multiplicity of proceedings. If we set aside and send this back to trial court, again that fresh evidence, then again that person who's lose, then they will file an appeal. All that can be avoided.
Then yes. They will carry out amendment of claim in the appellate court itself.
You carry out, let him file an additional written statement if he wants. Let the court wants frame the additional issue. If party wants to adduce additional evidence, they can be permitted. Then they can decide on it. Yes. Its appeal is filed by. Under Order 43, Rule 1U of CPC, challenging order dated 28 March 2023, passed by Senior Civil Judge JMFC Valanasura, in area number 31 of 2021, whereby appeal is allowed. The matter is remitted back to the trial court as consideration. For the convenience, what is our refer to the ranking as per that trial court. Plaintiff has filed a suit for declaration and possession. Declaration and mandatory injunction. What is that?
Declaration and mandatory.
Declaration and mandatory injunction. Trial court, by judgment and decree dated 29 September 2020, has dismissed the suit. Mandatory injunction in OS number 291 of 2012. The trial court, by judgment and decree dated 9 September 2021, dismissed the suit. Being agreed by the same, plaintiff has filed RA before regular first appeal before Civil Judge Senior Division Valanasura in area number 31 of 2021. Along with that appeal, he has filed IA under IA number 2 under order 6 rule 17 and IA number 3 under order 41 rule 27. The application has been allowed. The judgment and decree passed by the trial court has been set aside. The matter has been remitted back to the trial court for fresh consideration by the first appellate court by judgment dated 28 March 2023. Being agreed by the same, the defendant has filed this appeal. So and so learned counsel appearing for the defendant has contended that IA number 2 filed under order 7 rule 17 has been allowed without any reasons by permitted to amend the line by which the entire cause of action will be changed. He further contended that if, while allowing the order IA number 3 filed under order 41 rule 27, the trial court has not given any reason. The judgment and passed by trial court is without application of mind. Hence he sought for allowing that appeal. he further contended that even the trial court, the first appellate court has a power to frame additional issue, permitted the parties to adduce additional evidence and decide that appeal on merit without remanding the matter to the trial court. In support of his contention, relied on judgment of report MESA number 6164 of 2006, forth upon 8/12/2006. Hence, he sought for allowing that appeal. For contra, so learned counsel appearing for the plaintiff has contended that by allowing that application filed under Order 7, Rule 17, it will not change the nature of the relief sought in the suit. Earlier, they sought for declaration in respect of 30 guntas. Now it has been reduced to what is that extent? Huh? 3 guntas? 3 guntas, 3/4. Therefore, there is no any changes in the boundaries. And he further contended that during the pendency of the suit, there is a subsequent development. The same has been produced by filing an IN number 3 under Order 41, Rule 27. The first appellate court has rightly allowed that application and remanded the matter to the trial court for first consideration. Hence, he sought for dismissal of the appeal. Or the learned counsel for the parties arose judgment and degree. It is not in dispute. Plaintiff has filed a suit for declaration and mandatory injunction in respect of suit scheduled property measuring 28 guntas. The trial court, by judgment and degree dated 29 September 2020, has dismissed the suit. Being agreed by the same, the plaintiff has filed a regular first appeal in RA number 31 of 2021 before Senior Civil Judge Palanasipura. The plaintiff has filed IN number 2 under Order 6, Rule 17, seeking an amendment of plaintiff on the ground that during the pendency of the suit, some portions of the suit scheduled property has been sold. Therefore, he wants to amend that plaintiff. And he has also filed an application under Order 41, Rule 27 for production of additional documents which are related to subsequent event. During the pendency of the suit, he has sold some portion of the property. Trial court, considering that material available on records, has rightly allowed IN number 2 and 3. This court, the MESA 164 of 2006, has held as follows, para 11 and 12. In view of the above, remanding the matter by the trial court or remanding the matter by the first appeal court to the trial court is unsustainable. Accordingly, the appeal is allowed in part. The order dated 28 March 2023 passed in RA number 31 of 2021 by the senior civil judge Palainaspura in respect of set-asiding that judgment and degree dated 29/9/2020 in OS number 291 of 2012 passed by additional civil judge JMFC Palainaspura is set aside. Remanding the matter to the trial court is also set aside. The first appellate court is directed to permit that plaintiff to amend that plaintiff and permit the defendant to file a written statement. If necessary, the first appellate court can frame the traditional issue. If parties require for additional evidence, the first appellate court can permit it to adduce the additional evidence and decide that appeal in accordance with law. ಅದೆಲ್ಲ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬೇಕ್ರಿ ಎಲ್ಲವೂ CPC ಇರೋ ಪ್ರಾವಿಷನ್ ಅನ್ನಲ್ಲ ನಾನೇ you can file. You file application there that yes. If first appellate court has an power, they will do it. Yes. All pending applications are disposed. Yes.
Number 57. Examiner at Mahesh Aya.
Yes, learned counsel for the applying grace week's time. Reach this matter next week. Next week, Bharat. Yes. Today is the date. You argued. Yes.
Monday.
Bharat, next week, next Friday, Bharat. Yes.
Number 58, for petitioner, but
Yes.
petitioners.
Yes.
Yes, my lord, the lordship said examined, recently revised out to section 3 of section 125 of CRPC
Yes.
regarding the limitation stipulated for recovery of years of maintenance. Also, your lordship had examined the judgment of this honorable high court in Praveen Kumar versus Ashwini.
Yes.
An opportunity was given to the other side. He has any other judgment contrary to this.
Yes, 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 Mr. Have you verified that? What is this? Just give the brief facts.
On 25/7/2016, a petition was filed by the respondent wife against the husband in the series number 118 of 2016 under section 125 of CRPC.
Yes.
And after full dress trial between the parties and having considered rival contentions, the trial court came to the conclusion that the husband is liable to pay a sum of ₹8,000 every month to the wife until her last.
Yes.
And thereafter, my lord, on 25/9/2021.
Yes.
The wife filed a petition, another series, that is miscellaneous petition,
Yes.
seeking for recovery of arrears comprehending for a period of 29 months.
Yes, yes.
When the law envisages that
You said that only 1 year they
1
can.
year can be. That she filed petition, my lord. The husband filed his statement of objections, bringing it to the notice of the honorable court that any recovery of arrears beyond a period of 1 year is not permissible, and the petition is not maintainable to that extent.
Yes.
My lord, disregarding this aspect, my lord, the trial court proceeds to grant relief and direct for issue of warrant for recovery of the entire arrears of 29 months.
I think provision itself is clear.
Clear.
125.
125 subsection 3 proviso thereof.
Warrant shall be issued for recovery of any amount due under this section unless the application to be made to the court levy of such amount. Date on which it becomes due. Yes. Yes, Mr. Court has no power beyond 1 year to issue warrant. Or wait. What's 3?
This is a power to control the delay, certain receiving. How to say?
Notwithstanding anything contained in this foregoing provision of this chapter, only this chapter.
This chapter is only regarding
No. This chapter limitation taking a cognizance of creating an offense. Yes.
This chapter.
Yes.
This chapter is to limitation.
Limitation taking in a cognizance. Certain offense. Yes, not for all. Yes.
If it is satisfied on the facts and in the circumstances of the case, it has been properly explained. It is not that it is necessary to do so in the interest of justice.
Yes. Notwithstanding anything contained in this foregoing provision of this chapter, the court may take a cognizance in offense after expiry of the period of limitation, if it is satisfied on the facts and in the circumstances of the case, the delay has been properly explained. No, only in respect of this.
Before the limitation, how is it? There is a division under family court and under CRP is in fact, that aspect was at the threshold stage itself considered, and this honorable court has overruled that particular objection and held that it's maintained.
Order. When that order has been passed.
May I request your lordships, at the initial stage itself.
Of its objection raised regarding the mental it is overruled and the you have to recall that order.
I was not aware that order.
Otherwise, today if I say it is not maintainable, if this court in other bench has said it is maintainable, then it will be the two.
Division bench decision is there, my lord, that it's maintainable. It's ILR 1998 Karnataka 3068.
Yes.
It is maintainable.
Why it is not maintainable?
It's power of limitation identical under section 19 as well as under section 87. What is what's a right? Under 397 orders are not divisible. Similar to the problem section 19 surplus 4.
Because on its own motion or otherwise, call for and examine the record of which family participated within the jurisdiction part and chapter related to court. Not interlocutory order. Similarly, the problem in section 396, where courts have met with the interlocutory order, the revision is not made. Similar problem, but we are.
Then you convert it to writ, that's all.
Actually, the order which I have challenged, it has reached finality. Once for all, the trial court has adjudicated the petition and has directed for recovery of the entire maintenance by issuing warrant.
Attach warrant,
Yes.
the salary of the respondent, we have salary certificate.
There ends the matter of that petition. That's the final.
No. Attachment is there. Then that court has to see that whether you are entitled for pay that entire amount and all. They are saying that recovery. What is this judgment?
Pertaining to section 19, subsection 4. Rewarding.
No.
He not taking the maintenance to the wife. In other courts, when the petition is filed, first thing to be done is cost. Entire maintenance to be deposited before the court, unless that is done, petition itself could not have been entered. Here, the effect of this order would be to encourage violation of court.
No. For that, no limitation act has been fixed to that parties to approach court. See, order passed by that single judge has to be challenged within 30 days by the appeal. Limitation is there. See, after limitation you are filed, court cannot dismiss. You are allowing that to. But here you have to make out that whether that such a power is there. 473, it's only that chapter.
As your lordships have rightly perceived, yes. Applies to only that chapter. Yes. So far, cognizance of offences under IPC has to be taken, or of any other offence under various other legislations. Chapter 9 would not be applicable for this.
But it's not there. You show me any judgment on that. It is the same is applicable to chapter 9 also. Therefore, they have made it different chapter. Otherwise, they could have stated that they can be condoned that delay in that any CRPC. They should not mention that chapter. It is concerned, this court has overruled unless you file an application for recalling that order. I can't say that now it is not maintainable.
And even the division bench judgment is not clear. The division bench judgment is very clear. Revision is maintainable.
No, that is in respect of final order.
Final order. This is a final order bill.
Whether it is a final order.
It comprehends to recover the maintenance.
No,
Arrears.
that
Arrears
we can-
of maintenance.
That we can decide only if we file an application for recalling. Otherwise, why should I go there now? Now it is already held that it is maintainable.
Yes.
I was not aware that.
Then,
In fact, today, my lord, I have brought a check for 1 year, restricting the imputed order for 1 year.
to be upheld and so that I
No,
will
that-
make the payment also to you.
Now, if you able to convince the court and succeed, you have to pay 1 year. The check will return it, you will pay that all. Even today or even after 1 month. Yes. Now that law is very clear. The intention of the legislation may be, see, you have survived for more than 1 year without demand. Therefore, you need not claim for that. That may be the intention. See, 5 years, 6 years. No, see, 5 years, 6 years, even though there is an order in favor, you have not demanded that amount. The legislator thought that she is capable of surviving without that. Therefore, she can claim only 1 year. The second thing is the burden on the husband also. If you keep quiet for 5 years, then suddenly if you come and ask for an attachment, then it's a burden on him also. That therefore, legislator has thought that within 1 year you claim it.
This provision is there. Cannot not put so strictly so that to deny the maintenance of it. Not say anything further.
No, but legislator itself has fixed that.
The legislation is for
If there is no such,
available for that power can be exercised. So it says in the interest of this and for the application for
that I don't think if it is maintainability, we'll see. But regarding that 1 year, I think it's very clear. Yes, 21. Yes. At the request of counsel for the respondent. This is next week. Interim order granted earlier is extended till next date. Okay. Yes. No, that is there any interim order in his favor? Then we'll not extend that interim. We'll grant 4 weeks time, but will not extend that interim order. Even last occasion also not. What is that interim order?
First ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದೀವಿ ಈ ಡೇಟ್ ವರ್ಗೂ ಪೇಮೆಂಟ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ
7,500 ರೂಪಾಯಿ
ಹೌದು
per month we have to pay.
ಆ ಟಿಲ್ ಡೇಟ್ ವರ್ಗೂ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಒಂದು ವೀಕ್ ಟೈಮ್ ಕೊಟ್ಟರೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀವಿ
For that only you have taken the time.
ಅಪ್ಲೈ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ
When you have applied?
ಲಾಸ್ಟ್ 4 days ಬ್ಯಾಕ್
Very that.
ಲೋಯರ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಸಪರೇಟ್ ಇದ್ದಾರೆ ಅವರು ಅಪ್ಲೈ ಮಾಡಿದ್ರು
You show me that copy of that you have applied it. Then we'll say password. Yes. You have applied, we'll see. Yes.
All the best efforts of petitioner could not like the earlier order dated.
Yes. What is that earlier order?
13/1/2023, not was directed to pay 50% of the amount.
What's the date? 13?
13/1/2023. He has paid only a sum of 60,000.
That's sufficient delay. Interim order of as right for subject to the petitioner depositing 50% of the arrears of maintenance payable to the respondent. Here within 4 weeks from today before the trial court. You have not complied.
Hardly compared to was paid. Wherein the total amount supposed to be paid was 96,000. was the due amount.
36,000 kodi.
The onwards. If it is a rainy days, is not able to get a job in on a daily basis.
Can you execute that order?
Not petition.
That amount will be released. Yes. You file an application. Have you filed it? No, for releasing that amount, you have to file an application, madam. You have to file an application with the affidavit of the parties. You file it next week. Yes.
It can be disposed of. Ex parte order has been challenged before this. The grievance of the petitioner is not the amount ordered by the trial court is exorbitant.
No, that will send it back only if you pay that arrears also.
Please.
You are not complying this court order, then what rights you have to seek for this thing, remanding that matter?
3 weeks is granted, but somehow petitioner may arrange the amount.
No, that for that purpose only we have granted any time.
However, this efforts she could not.
Yes, anyhow that she has to file an application next week.
Please.
By the time we pay some amount, it's better.
Please.
Yes, release this matter next week. You file an application for release. You're directed to release. Yes.
Number 61, second year for petitioner connected matter, Imad Gowda.
Yes. Notice not ordered. We will take notice. What is?
In this petition, we are seeking for 50% of maintenance.
No,
The earlier amount has been paid, my lord.
Who are you?
We are for petitioner, my lord.
Wife.
Wife and children's, my lord.
What is that order passed by the trial court?
My lord, in trial court, it has been partially allowed by giving 15,000 maintenance for my lord.
Where is that order?
My lord, in page number 29, my lord. The order that a respondent shall regularly pay 15,000 per month, my lord. For respondent number 1, my lord. And for each children, rupees 1,000 has to be paid, my lord. There are 2 children, they are minor, my lord. My lord, the respondent is.
What is that petitioner? What is that you are saying? Yes.
Has a salary of 1,19,000, my lord.
Now that as per that interim order, you are paying that. Yes. Now that wife is filed an appeal for enhancement.
My lord, sir, the arrears 50% he has paid, my lord. But in my memo of calculation, my lord, the amount which is pending is 2,52,900, my lord.
Where is that memo of calculation? How much you have paid?
10,722.
There is that order. When that order passed by this court? Now the entry matter pass. What is the date, Mr.? February.
2023.
21/6. 21/6. ಯಾವ ಮ್ಯಾಟರ್ ಮಾಡಿರ್ತೀರಿ?
RPXD 10. 3 to 2023. RPXD 10, my lord. Standard matter it has been done.
Interim order as per for subject to the condition the petitioner deposit 50% of the arrears of award amount within 4 weeks from today. What is that 50%? ಅಂದ್ರೆ 7,500. ಯಾವತ್ತಿಂದ ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ? $7,500 from the date of order.
Yes, amount is 2,52,900.
ಎಲ್ಲಿಂದ 8th December 2022 ಇಂದ ಅದೇಂದ್ರೆ ಆಗುತ್ತೆ 2 lakhs. How it becomes 2 lakhs, mister?
My lords, in when the interim order in the suit was granted, it is 25,000, my lord.
Huh?
But they have paid only 1,19,000, my lord. When the suit was pending in the trial court, the interim maintenance was granted 25,000 of interim maintenance was granted, my lord.
You file a memo of calculation after serving copy to him.
My lords, we have filed a memo of calculation, my lord.
ಎಲ್ಲಿದೆ? Have you served a copy to him?
10/7/2023.
10/7?
2023.
Yes, you
My
also
lords,
file a
they have there was a direction to file a memo of calculation, my lord, for that.
If you take notice to them.
My lords, there is urgency in interim maintenance, my lords. They are not paying school fees for children's.
No, that have you deposited here? You file in a memo of calculation after serving. We'll post this matter next week. Yes.
My lord, interim maintenance urgency. ಅದು ಸ್ಕೂಲ್ ಮಕ್ಕಳಿಗೆ ಫೀಸ್ ಎಲ್ಲ ಕಟ್ತೀವಿ ನಾವು.
You file in a memo after serving it. We'll see that. Yes.
My lords, on day to be fixed.
Next week. Next Thursday. Next Thursday. You don't want to take notice? ಇದರಲ್ಲಿ 87 ಅಲ್ಲಿ issue notice to respondent. Learned Council notice not ordered. Learned Council for delete the name of Vinod Gowda for respondent and issue notice to that respondent. Yes, release this matter next week. Next week you file in a memo in your case for the complying that order. Yes.
Disposal matter, serial number 62, Shekhar Badigar, Shruti Kangati for appellant, Swedish Purana, answering for respondent.
Ready in the manual.
Yes, Mr. Pastor.
Hearing matter, serial number 63, Swedish Purana for appellant, Krishna Satish Kumar,
Pastor.
64, BD Patil for appellant, M. Shiva Prasad.
So.
My lord, 2:30 we have some matter.
Yes. At the request of the parties, release this matter next week.
Sanjay Nayan for appellant, Ganesh Chennai.
We have provided.
Yes, where is the Nayan?
Kindly pass out, he'll appear in.
Next week.
Please.
Next week. Yes, release this matter next week. Yes.
I have given them all a win-win situation.
Yes, let us see what is that suggestion. Next Thursday. Next Thursday.
Please.
Yes.
Next week and
Next week until next Thursday. 53 Thursday. Next Thursday.
I'm for appellant. Monday, it is for injection and pick up for results.
No, pass over. Yes. You are appearing for whom? Yes. When do you want? Next week.
Monday date may be fixed.
Monday agala. Wednesday. So not Wednesday. Tuesday.
Wednesday may be fixed.
No, Wednesday we have motor vehicles matter. Or Thursday.
Thursday.
Yes, Thursday.
ಅಲ್ಲ ಸರ್
matter, is number 1, serial number 5, Vijay Kumar CM for petitioner, Kevin Narasimhan.
Yes, yes, yes.
Number 4, HP Manjunath.
There is no order earlier, Mr. You're not seeing that order sheet. It's only in respect of the name of the petitioner number 2.
Signature is Ma Manjunath.
That is not petitioner number 2. That is petitioner number 4. Which is that office objection? Office objection number
12.
Huh?
12.
12. Huh? Office objection in respect of serial number 12. Submission of learned counsel for the petitioner is accepted. Office objection is overruled. Yes, use this matter next week.
Number 9, for petitioner.
Yes, you have complied. Yes. Learned counsel for the petitioner service that office objection has been complied. Office to verify and proceed further.
Please take it down for petitioner.
Yes, Kiri Rao.
Very minor objection that has been complied. You can see in the matter was not.
Proposed what fee to be made good.
It has been, all that has been made.
All that has been.
Yes.
Verification of the.
Second round of objections was very minor with respect to pin code ಮತ್ತೆ judgment ಸರಿಯಾಗಿ ಸುಲಿಬೇಕಿತ್ತು ಸರ್.
Objection. There are 7 objections.
Complaint. It has been all of
Now you has complained or
ಬೆಳಿಗ್ಗೆ ಎಲ್ಲ ಕೂತ್ಕೊಂಡು
Mission put me leak put
ಮಾಡಿದ್ದಾರೆ. Yes. Proper court fee to be made good.
it has been.
Yes, challenge impugn order to be stitched immediately after the
That has also
disposal of the date, impugn order to be corrected, period to be dated, trial court details to be stated that they cost like it. Yes, what is this matter?
Yes, sir. To put it very shortly, Manoj.
Yes.
Suit for ejectment.
Yes,
I was the tenant.
yes,
Suit came to be decreed.
yes,
Thereafter, Manoj, execution was filed.
yes,
Pending the earlier execution, Manoj, we entered into a fresh listing. Thereafter, the previous execution was dismissed for non-prosecution. This execution was dismissed for non-prosecution in 2016. My lease deed was also in the year 2016. Because we had entered into a lease deed, Manoj, the landlord did not proceed. 2018, Manoj, one more execution is filed on the same judgment ending,
yes.
previous judgment ending. Now, Manoj, delivery warrant is being issued on that. This is a registered lease.
Now that have you brought to the notice
Yes,
of the court?
yes, yes.
Now, what is that
The
finding?
court Manoj, after considering it in a detailed manner, Manoj, at para 18, Manoj, running page 49.
Yes,
Manoj, the court comes to a conclusion.
Hmm.
Though there is a registered lease deed,
Hmm.
it pertains to the same property. It is subsequent to the decree. I cannot go behind my decree. This is the view which has been taken by the court. It's a order in Canada.
where is that delivery warrant issued by the court?
Manoj, sir, the operative portion itself says.
No, now that where is that?
50ನೇ page ನಲ್ಲಿ
Hmm.
ಅರ್ಜಿಯಲ್ಲಿ top 5th line from
Which page number?
50.
Yes. ಸ್ವಾಧೀನ ಪಡೆದಿತ್ತೆಂಬ ಕಾರಣಗಳಿಂದ
ವಾರೆಂಟ್ ಅನ್ನು ರದ್ದುಗೊಳಿಸಲು ಬರುವುದಿಲ್ಲ.
ಹಿಂದಕ್ಕೆ ಪಡೆದುಕೊಂಡು ಬರುವುದಿಲ್ಲವೆಂದು ತೀರ್ಮಾನ
ಹಿಂದಕ್ಕೆ ಬರುವುದಿಲ್ಲ ತೀರ್ಮಾನಕ್ಕೆ ಬರಲಾಗುತ್ತದೆ.
ಚರ್ಚೆಯಿಂದ
The decree Manoj is now discharged by virtue of a fresh lease deed.
Yes.
47 speaks Manoj of complaints discharge. The question which was before the court Manoj was whether the decree was discharged in view of a fresh registered lease deed.
Yes.
The court has not gone into the said question.
Yes.
Manoj, it has applied an approach.
Issue notice. Then at council for the petitioner submits that office objection has been complied. Office will verify and proceed further. Issue emergent notice to respondent. Stay of further proceedings in execution 24 of 2018. Getting principal civil judge and Nanjangud till next date of hearing.
Number 23, Bharat paper opponent, standard matter, very large letter, 550.
23, yes.
Number proceeding.
Next week,
Looks, I think Monday or Tuesday, Monday.
next Thursday. Is this matter on first?
Number 24, SP Patma petitioner,
Yes. Yes, you made that. What is this, Mr. But what is the?
The order of the challenge in RFA was. Quite by the opponent in the RFA.
Yes. Now, where is that?
Level.
Hmm.
A and D, that is want of action and the limitation. Say that the court has no jurisdiction because 1984 is agreement to sell,
Yes.
1984. That was sought to be executed, that was sought to be specifically enforced in 1986 for the first time.
Yes.
That suit came dismissed. Ultimately, after Supreme Court, the event of Supreme Court came dismissed. On the ground that the appellant before your lordship was not there, it is not a registered association and it's a bar.
Yes.
It is thereafter, they say that they have registered it once again based on the same agreement. Second suit came filed in 2016. The second respondent, that is the public article trust. That suit, the trust itself has made an application to Article 11 A and D in view of the earlier judgments also. The court came to the conclusion that yes, the want of cause does not survive, is liable to be rejected, and also on the ground of limitation. That order was challenged before your lordship in the RFA.
Yes.
1294 of 2022.
Yes.
Before this honorable court, the very same trust enters into an compromise petition before your lordship, and an order can be filed.
What is that settlement?
The settlement is to specifically enforce that agreement only. They say that they are going to sell the property, very same property.
The properties belongs to trust.
Trust.
They want to sell.
Yes.
What is your interest?
My interest is a public, number one, it's a public charitable trust. What permission was required to take? They have not taken the court permission.
No, that trust is also represented.
Trustees representing one trustee. There are two trustees. Only one trustee represents the.
Now,
trust.
what is the threat now?
The threat is not. They have sold the property. The 15th February 2023.
Yes.
Compromise is entered into on the same day. Same day is the executed.
Now, what is that interim order you are sought for? There is
I
delay also. There is a delay.
Yes.
Delay in filing a.
I was not a part of the reason I was not aware of it.
No, that now that revision can be review can be filed by any person,
Yes.
or only that person
Yes.
part,
No,
any agreed person.
The
Yes. Section
Section 114. Any person considering himself aggrieved, that is what
Yes.
any person considering himself aggrieved. Today, Supreme Court relied on 2018. In case of the Union of India versus Naresh Kumar.
Yes.
As they said,
No, what is the delay? What is that? How many days delay?
There is about 90 days delay.
There is a delay in filing the review petition. Learned Counsel for petitioner has submitted that they are not a parties. They are not a party in RFA 1294 of 2022. It was up on 15 February 2023. They immediately after come to that knowledge, they have filed that review petition. He further contended that the trustees colluded with other parties, filed a compromise petition before this court, and they are alienated the property. In view of the above, in a peculiar fact and circumstance of the case, pending consideration of IFR condemnation of delay, they have what is that? Stay of order dated 15 February 2023.
Yes.
Passed in RFA 1294 of 2022 till next date of hearing. Issue emergent notice.
Interesting thing is that they have not sought for the trial court decree has not been satisfied. Only in terms of the same what I give permission for it, and they will compromise that point.
Yes, yes. You see that. Subjection. This objection complied. Yes, Learned Counsel for first relief. Office objection is complied. Office to verify and proceed. Amala interim.
Number 35, Prashant BG for appellant.
Lord, I beg to appear for the appellants.
Yes.
Lord, 5 to 38.
Yes.
Arise from a common order. Your lordships
Yes.
may recall, my lord, that in another appeal, MFA number 5530, your lordships have been pleased to issue notice and grant an interim order, my lord, on 14/8/23.
Please. The similar matter.
Yes, my lord. It's from the same order, my lord. What happened was, your lordships heard me and passed the interim order. There were that order of the lower court, my lord, covered 5 applications. So we filed 5 different appeals. In fact, your
5
lordship,
different.
yes, it's the same common order, but different reliefs have been sought, my lord. Most extraordinary reliefs. That bank 306 crores is due.
Yes, yes, yes. Issue notice.
Your lordships have
notice to the
stay in
respondent.
IA1 in those cases, my lord. In these cases, your lordships may have to pass an order, my lord, staying orders passed in IA numbers 2, 3, 4, and 5.
No, that impugn order in this this thing.
In this appeal, my lord.
No, common order has been passed.
A common order is passed. When I filed appeal against IA1, your lordships have granted stay of order on IA1.
Now that 2 and 3.
2, 3, 4, and 5, my lord. There are 4 appeals before your lordships today.
Yes, that is in the serial number.
35. Order is on
35 is-
IA number 1. Serial number 35, my lord.
Yes.
MFA 5527. The
Yes.
trial court order is on IA number 2.
IA number 2, yes.
In 5528
Yes.
is IA number 4.
IA number 4, yes.
5529 it's IA
Yes.
number 5.
Yes.
And 5538 IA number 3, my lord.
Yes. Order is same. Order dated same.
Same date, my lord.
Order stay of
Common
impugn
order.
dated 18/7/2023 passed by 18th Additional City Civil Judge Bangalore on IA number 2 in OS number 2180 of 2023 until further orders. ಇದೇ ತರ ಬರ್ಕೊಂಡ್ರಲ್ಲ 2453. Yes.
Grateful. Lord, there is an
of 2023 for dispensation. Dispensation of what?
Lord, the pleadings in the trial court have been filed in MFA 5530. So it's identical, same document.
Yes, IA 1 of 2023 is allowed. Dispensation of production of, is it production or certified typing? What is the
Production, because the
Production,
claim,
yes.
Yes, production.
Yes, production of documents dispensed. Yes.
You know, these 4 matters may be tagged with the main appeal.
Yes, call this matter along with the.
MFA 5530 of 2020.
Yes,
23.
I'll copy the note. Yes, yes.
Right.
Second, third respondent address. The address is US address. You take out notice to US address also. In the latest stage, they give the regular address. It is permitted to take out notice to that address also.
You pay the process for both.
For both,
Yes.
office may not send the notice to other addresses only. The address given in the petition only they will send it.
Now take hand summons.
And some of them will not be available. One case will address.
No, they will come now. Now we have granted interim order. They will come. Why do you worry? Yes. They will come then. Yes.
Please, ma'am.
Yes.
What is the case for a petitioner or the Sadashiv?
Yes, Mr. Uday said. No, that. Yes, Mr. Uday, what is the stage now? Now that parties are under evidence, now you want to prosecute this appeal.
Because even in the plain, my lord, the plaintiff do not say. When it is the tenant of complaint.
Yes.
Government with regard to relationship and to tenant and the that's not doing in make it. The tenant under. It is father being paid of.
Yes.
In Payrappa, I debated and we did in favor of it. Not if we should have noticed calling upon the petitioner to vacate and add of the vacancy. He gave a reply stating that I am not. Your father gave Payrappa, he put me in possession of the property and paying it regularly to give Payrappa. But there is a proof for partition pending amongst.
No, father is alive.
Father is alive.
Yes.
Father is alive. The contention of the plaintiff is that there was a partition in the year 1977. Thereafter, he became the absolute owner of.
No, can that be decided in that this thing, rejection of claim? See, you are not denying that you are the tenant.
I am the tenant under PM Payrappa.
Yes, but it is not your case that you are the owner of the property or the mortgage.
PM Payrappa has not initiated eviction proceedings against me.
Yes.
He is the owner of some separate property.
Who is that Suresh?
Plaintiff is owner of another property.
He is not a owner of
He
the
is not
property.
owner of this particular property.
Yes.
That is the contention, but not taken up by the.
What is that order passed by the trial court?
Why not trial court reasoning of the plaintiff, trial court may not is at the page 17 paragraph 95. It says that since petitioner, the defendant admits that he is the tenant under father, by operation of law, he has become a tenant of. That, my lord, in case of transfer of property, the property is transferred from one owner to another owner. Autonomy takes place by operation of law. The tenant under previous owner becomes the tenant under the new owner.
Yes.
But here, there is no transfer of title. Title which existed earlier has been crystallized by the alleged party.
Yes.
So, the observation made at the paragraph 9 not that the operation of law.
Property has fallen to the share of the plaintiff. Father of the plaintiff is also party to the said partition deed, which had been taken place in 43 years ago. The plaintiff has pleaded that when the defendant has admitted that she is a tenant under the view of the registered partition deed 1977. There was a partition deed in 77. The shares has been transferred to that daughter. She will inherit it.
No, my lord. I am being indicted subsequent to that partition. Year 2009, I have been indicted as a tenant.
Yes.
But your lordship may clearly see the plaintiff.
Suppose if the wrong person has been inducted you as a tenant,
In the plain, my lord, the plaintiff states that I am tenant under, the defendant is the tenant under claim.
Yes.
Or he says that under what circumstances the defendant has become a tenant under claim.
By partition deed.
No, my lord. Partition took place in the year 1977.
So,
I have been inducted as a tenant by B.M. Bhairappa in the year 2009.
that can be decided at this stage.
There is no pleadings with regard to that, my lord.
The pleadings is that she has inducted you.
No.
What is that pleading in that plaint?
He plaintiff never says how I became tenant.
Where is the plaint?
Plaint, my lord, is at page 21. So, sorry, 19. Event address with regard to relation status from
Plaintiff is the one or plaintiff that defendant herein is the occupant of the portion of the social.
para 4 if you are not mistaken.
Hmm.
Plaintiff submits the dependent in the dependent hearing is an occupation of portion of A schedule property using 10 feet into 30 feet. That is shop premises number 4, which is mostly described as schedule B here under and herein after referred to as schedule B property. On a rate of rupees 10,000. Month of tenancy of English calendar, month commencing from when. The featured property which is the subject matter of the food is there. Plaintiff submits the schedule B property which is an occupation of the defendant is required by the plaintiff for his self-occupation and the defendant has failed to vacate and deliver the vacant property.
What is the notice there discloses?
Notice also disclosed. Notice also they won't say when the defendant becomes tenant under the.
Where is that notice? Have you produced that copy?
Notice,
You have that copy? Yes, Mr. What is that? Yes. That's what I am asking. If the wrong person has been inducted you, but admittedly,
there is a suit pending.
plaintiff is the owner.
There is a suit pending. In OS number 4014 of 2017, filed by plaintiff system against plaintiff and his mother. Even mother has written a letter.
If that would be that complication, can it be rejected at the stage of?
Because there is no relationship of landlord and tenant. It has to be rejected.
No, that see that evidence. How can you say that by without going to that evidence?
He has to establish there is a relationship.
No, that on the pleading she said that she is the owner. Now, see, rejection of the plaint is only on the basis of that pleadings in the plaint. It can't go beyond that. She said that she is the owner by partition. Now you are by written statement or objection saying that she is not the owner. That has to be by a trial.
May not see schedule B property in the partition for legal busy.
I agree. Otherwise, court can you look into that now? By seeing the plaint, it shows that there is no cause of action.
My lord,
Then
by
it
seeing
can-
the plaint itself, it shows that if he is the owner of the property and I am in illegal possession, his remedy is to file a suit for possession and not for rejection.
No, she has not said that illegal possession. She said that you are a tenant. Whether illegal possession, that is your case.
Plaintiff, dependent is the tenant of the place.
Then what is that she has said? You see that para 4? Para 4 of the plaint.
Please. Dependent hearing is in occupation of portion of A schedule of the schedule A property during 10 feet into 20 feet. That is
Monthly rent of 10,000 under ಏನು ಅರ್ಥ ಅದು? Tenant. Then notice has been issued under 106 of
notice has been issued. There is a specific denial with regard to.
you raise all the contention before the trial court. It is not the case for rejection of the plaint. You maybe
prima facie should, at least he must be able to state that when I was inducted as a tenant.
No, that need not be. Where is that law shows that for the eviction suit for ejectment, they should show that when it has been inducted. Only thing is that they have to prove that relationship of tenant and the landlord. That is only after the evidence.
Even otherwise, he says that I am the tenant, he admits that I am the tenant under.
Unless if you take in a contention that you are the owner of the property, she is not a tenant, if you produce that document, then it's different. You are admitting that you are in a tenant, but not under that plaintiff, under his father. Whether father is the landlord, all that has to be decided in the trial.
Even today, the petitioner is paying rent to his father.
You pay, rent can be paid to anybody. Person owner will be in that oversee. That rent can be paid to the somebody. Then he will lose that ownership.
Rental agreement has been executed by the plaintiff's father, stating that he is the owner of the property. He is rejected me as a tenant.
That is not the case for rejection of plaint. Yes, that's all. This petition is filed by defendant challenging order dated first September 2022, passed by 14th Additional City Civil Judge, Bangalore, on IA number 2, filed under Order 7, Rule 11, in OS number 3289 of 2020, whereby IA number 2 is rejected. For convenience, parties are referred to the ranking as per the trial court. Plaintiff filed a suit for ejectment. After service of summons, defendant appear through their counsel as filed IA number 2 under Order 7, Rule 11, seeking rejection of the plaint. This is all for dragging that case or this thing. Yes, Allah. After service of summons, appear through their counsel, filed in a written statement. Later, they filed an application, IA number 2 under Order 11, Order 7, Rule 11, for rejection of the plaint on the ground that there is no relationship of landlord and the tenant. Plaintiff is not the landlord. Trial court, after considering that arguments of the parties, has rejected the plaint, has rejected that application. By reading the plaint, the plaintiff has clearly stated that she is the landlord, the defendant is the tenant for monthly rent of rupees 10,000. And the specific case of the plaintiff that she is the owner of the property by partition among the family members in partition deed dated 15/6/1977. The defendant has denying that same. The plaint can be rejected under Order 7, Rule 11 only on the basis of the plaint. The question raised by the defendant cannot be decided at this stage going to the trial. Therefore, Trial court has rightly rejected that application filed under Order 11, Rule 7 of CPC. There is no error in the order passed by the trial court on IA number 2. Hence, I decline to interfere into that order. Accordingly, petition is dismissed. All pending applications are disposed of. Yes. Yes, what is the stage now? Yes, the trial court is directed to dispose of the suit itself on merit on or before 6 months, within 6 months from date of receipt of copy of this order. Both the parties are directed to cooperate for early disclosure. Yes.
Number 48, Santosh is going for appellant, please Srinivas.
I'm for the respondent 6 to 20 minutes.
Yes.
I find my wakalat, it's not very good now. Yes.
Now that we'll see, he's saying that some urgency. Now that what is that urgency till Tuesday? Tuesday. Yes, we'll have to.
They not create third party.
No, that don't do it in between. Then I will protect his interest. What is the purpose of filing in a writ petition and taking in a time? In between that you are doing. That is true. No, even before, even yesterday or before today, if you are alienated, it is nothing. But taking a time from this court and your party. No, that is true. Then you have to be instructed your party, don't do it 2 days.
Okay, Tuesday.
Yes, 2 days. Otherwise, this is nothing but doing a fraud on the court, taking a time and do. Yes, you should be confident on your party also. Yes, Tuesday. Yes. Wednesday. Wednesday.
Please.
Yes. Thursday. Then Thursday. Yes.
Prashant Chandra SN for appellant, Hindi Onkarappa.
Yes. Yes. What is this, Mr.
Appeal Malad filed against passed by the trial court Malad invoice number 2323 of 2023.
Suit for?
Suit for injunction.
Yes. You are appealing for a defendant.
I am appealing for the defendant.
Defendant. Defendant appeal. What is that IA?
IA Malad is under Order 39 for Malad seeking temporary injunction against the defendants from interfering as well as Malad further constructing the building.
Yes.
A residential building.
Yes.
The residential building Malad is in halfway.
Now, what is that? On what ground he has filing in a suit for injunction?
He seeks Malad a relief that 5 guntas of land has come to the share of the plaintiff, she has come to her share through her ancestors, and defendant Malad is constructing a house in a property which she claims that belongs to her.
Yes. What is your sources of?
My source, my lord, is that originally this property was not this property.
Yes.
Amongst other survey numbers.
Yes.
Were taken by the aircraft employees housing cooperative building of limited.
Yes.
In that, my lord, one of the survey number is 68/1.
Yes.
In which, my lord, the property of the defendant site which was allotted to Lord 1 Narayana on 11/10/2004 by the society. Lord, he sold that property in favor of Srinivasan and Sujata Gopalaswamy.
Yes.
On 21/10/2004.
Yes.
Thereafter, Shekhar, Srinivasan and Sujata Gopalaswamy sold the site in favor of the defendants.
Yes.
On 15/2/2020.
Yes.
In the year 2022, defendants obtained, my lord, the permission from the BBMP for construction of, my lord, the residential building.
Yes.
Sanction plan was issued. In 2020, when the sale deed was after the sale deed was executed, my lord, the son of the plaintiff and daughter-in-law,
Yes.
they objected taking possession. But they were shooed away by the defendant, saying that it's our property and we have got it from a sale deed. When the construction happened in the year 2022, again they came and objected for construction. The defendant filed a suit in OS number 1532 of 2022 against the son of the plaintiff.
Yes.
And the daughter-in-law. Notice was issued to them. They did not appear. My lord, the defendant argued the matter and injunction, temporary injunction order was obtained. The plaintiff files the present suit in her individual capacity, saying that I am the owner of this property. That
What is their sources of title?
their source, well, and according to them, is that they have got it from their family. In Pavati Khata, the 5 guntas of land was given to her.
No, this is that property which has been acquired by the society
It
from
was
their.
not acquired. They say, my lord, their property falls in survey number 72/5, that is 5 guntas.
Now, what is the stage in the construction?
My lord, but I will just show.
Yes. Have you taken that permission from the competent authority land section?
Yes, my lord, everything I have produced before that court.
Now that by stopping the construction, you will not get any benefit. You will undertake that if he fails, you will not claim any equity. I will hear you. I will hear you. Before that, this is the this thing by stopping that construction in the middle. Admittedly,
This photograph is produced by the plaintiff.
admittedly, he is in the possession of the property he has constructed. It is not 1 or 2 days. It is from long time. It is there. Now that stopping the construction will not give any benefit. Even if it is construct, let him give an undertaking that he will not claim any equity. Or if you say that if you succeed, you want that vacant land, let him undertake that he will remove everything and give an vacant. Yes, then
I have another answer.
Yes. Yes.
As far as the basic property is concerned, it is there 7/72/5.
Yes.
Whether you want 5 guntas.
Yes.
This property is not at all acquired by this society.
We are not saying, we are admitting everything.
Yes, yes.
There is no
Let him.
That property comes in 8/1. More property is 72/5.
No, now that it is a different property, but they are constructing in your property. Now that even assuming that this construction is coming up in your property, let him construct. If you succeed, it will go.
That's what my objection
Tomorrow,
is.
court held that it is not their property. They have no right. Therefore, they have been injected from interfering permanently. Then, as per that undertaking, he can't claim any equity. Yes, he given it.
There is no issues, my lord. This, in fact, I have produced this judgment.
No, now that we need not go for any further this
No,
thing.
no, what I'm saying, in fact, I had produced the judgment of the Supreme Court. Same extent, where the court has passed an order
Yes.
that subject to the result of the petition, but unfortunately, this judgment has not been taken into consideration by
Opinion that in interest of
by the court at all.
justice, while allowing the respondent to carry out the construction of the building, made subject to the ultimate decision of the suit, the trial court is requested to hear and dispose of the suit as early as possible. A third party's interest is created upon completion of the construction. The briefs questions are clearly stipulate that matter is subject to division. Now here, court has given a further relief also to eliminate. All that will not give. He can't create third party interest. Only for the construction.
But this is a residential building, it's not a commercial building.
No, no.
It is for themselves.
No, even I will prescribe only for the construction. You should not create third party interest.
I
If
will
you
not.
succeed, you can't claim any equity. Yes. Yes.
Site number 385 bar A, 385 bar B and B, they have assigned.
Yes.
How they have sold the property, kindly, the page number.
Now, one thing, no, this is not the issue that even assuming that if it is your property, he is illegally, he is constructing that in that your property is already in the possession.
But
Then that remedy should be that for possession.
declaration of position, at least. That is even not in defined.
No, that is not the issue before that. Why we have to go on.
Kindly see.
Yes, we'll see. Yes. No, wait. What is the stage in the suit now?
But your lordship, for a moment, kindly see page
No,
39.
that will permit you
I,
not to claim equity and also directed to dispose of the suit as early as possible.
your lordship, kindly for a moment, kindly see page 39.
Yes. Yes.
The schedule,
Yes.
all that parcel property bearing number 72/5, measuring 5 untas.
Yes.
They are claiming injunction as it is the entire property, whereas my property is only 2,400 square.
No, all that, let the trial court decide. I'm not deciding. Yes. Even though in yaridara ಎಲ್ಲರೂ ಸರ್ವಿಸ್ ಆಯ್ತಾ?
Only the different area.
Yes. Yes.
Society and
Yeah.
within 10 days, we have come to another person.
What is the difficulty?
You have obtained property without assigning the right.
No, that to purchase the property is the same property.
No, my lord.
No, you are saying that.
Site number 385 bar A. How they are not site number 385.
No, that we forget about site number boundary. Same boundary is tallied to.
Our property is 15 bar there.
Yes, yeah, let that trial. Yes, third. Even though matter is posted for admission, the consent of the parties taken it for final hearing. This appeal is filed by the defendant number 1 and 2 under order 43, rule 1R of CPC, challenging
One more appeal is there. But arising out of the same one.
Why two appeals?
The one was an application filed by me for vacating in the interim order. That was rejected. His application, my lord,
No, that has been rejected and common order has been passed.
Common.
ಅದಕ್ಕೊಂದು appeal ಹಾಕಿದ್ದೀರಾ?
ಅದಕ್ಕೊಂದು ಇನ್ನೊಂದು.
You could have mentioned in
My lord, it is common. There is no change at all. It is one there. Findings ಎಲ್ಲ ಒಂದೇ.
Yes, but I think one is maintainable.
One is maintainable.
No, why you have filed two?
But my lord, the two orders are there. Here the observation will active. And let me explain. I can understand his anxiety to argue.
Yes.
My lord, one is an application filed by me for
Yeah.
vacating the interim order. Other is, my lord, an application filed by the grantee for grant of interim injunction order. To separate, my lord, for all purposes, it will be treated as two separate orders.
Yes.
Therefore, my lord, I filed another appeal also.
No, but what I am seeing in that regularly, they are filing only one this thing.
But ನಮ್ಮಲ್ಲಿ ಏನಂತ ಒಂದು objection raise ಮಾಡಬಾರದಲ್ಲ ಅಂತ ನಾವು ಹಾಕಿದ್ವಿ.
Yes, that's true. Allah, usually, see what has happened. They will grant an ex parte injunction order. After appearance, defendant in file an application for vacating. Clubbed together, the order will pass either allowing that IA1 and rejecting that. Then all that they are filing that one. Either of them has to file two if they want to challenge. But they are filing in one, then obviously is not raising an objection. Actually, that two IAs, there should be a two order. Yes.
Correct.
Now that which is that other appeal?
That is 5196.
That will also get it now. Anyhow, that he has taken notice. Other notice ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಅದು yes. Letter club ಮಾಡ್ಕೊಂಡು. Challenging order dated 10th July 2023 passed by 29th Additional City Civil and Session Judge, Bangalore, whereby IA number 1 filed by the plaintiff is allowed, and IA number, your IAS,
Rule 4.
what is the IA number 2 filed by the defendant is rejected. Plaintiff has filed the suit for their injunction. Ex parte order ಏನಾರು ಇತ್ತಾ? Yes. Yes. Their injunction. The trial court has granted an ex parte injunction order restraining the defendant from interfering and put up construction in the suit scheduled property. On service of summons, defendant appear through counsel filed an IA number 2 for vacating the ex parte injunction order. The trial court clubbed that IA number 1 and 2 cause an impugn order, allowing that IA number 1 filed by the plaintiff under Order 39, Rule 1 and 2, restraining the defendant from putting up construction on the suit scheduled property pending disposal of the suit, and rejected IA number 2 for vacating the ex parte interim order. Being agreed by the same, the defendant has filed these 2 appeals. It is not in dispute that the defendant has put up, defendants has putting up a construction in the suit scheduled property. Now that parties has, now the pleadings has completed. Yes. Issue has to be framed under these circumstances, and in the interest of justice, put up in a construction. The learned counsel for the appellant defendant has submitted that the defendant has putting up the construction after obtaining necessary permission from the competent authority and after obtaining the plan. At this stage, if appellant is defendant is restrained from putting up further construction, it will cause loss to that defendant. And he contended that in case plaintiff is succeeded in the suit, he will not claim any equity. In view of the above, and in the interest of justice, the defendant is permitted to put up further construction in accordance with law without claiming any equity. Accordingly, the appeal is disposed of. Order dated so and so is modified to the effect that appellant, the defendant is permitted to put up a construction in suit scheduled property in accordance with law.
Suit property, that because we don't concede, my lord, we are constructing suit property.
No, that
Now number statement of
yes, permitted to put up a construction in accordance with law. In case if plaintiff is succeed, that defendant is not claiming any equity, the trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of the copy of this order. Both the parties are directed to cooperate for early disposal. Yes. All pending applications are disposed of.
Narayanan Myanmar for petitioner Rajesh A.
Monday. Yes, let us see that if he has not paid that, then we'll know that if you are deposited, they might have known that because they have received that amount. Your party is not Monday. If you are not produced, yes, then I will dismiss it. Yes, Monday.
Number 52, legal particular, Deputy Surana.
Yes. Yes.
Dismissing my application under 39. And an interim order during the pendency of the application.
Yes.
And an interim order is also enforced in the present.
Now that suit for
Suit is for cancellation of all fees.
No,
Which were executed by me in favor of defendant.
no, you are in a plaintiff or a defendant.
And the plaintiffs were my suit. I has been dismissed.
Yes, plaintiff. Okay.
Suit, the prayer in the suit is for cancellation of 4 gift deeds which were executed in favor of defendant.
Yes.
Dated 5/8/2014. Now plaintiff number 1 and defendant are brothers.
Yes.
Plaintiff
Number 1.
Plaintiff number 1 and defendant are brothers.
Wow, who is that plaintiff number 2?
Plaintiff number 2 is the wife of plaintiff number 1. That is
Yes.
the defendant's sister-in-law.
Yes.
Now the gift deeds have been executed in relation to two properties, my lord. Schedule
Yes.
A property, which is number 14/2.
Yes.
And Schedule B1 property, which is 1/4 share of Schedule B property. That
Yes.
is 1/4 share of number 14/1.
Yes.
Now plaintiff 2 had acquired rights in Schedule A property under the sale deed dated 30/12/1987.
Yes.
Plaintiff number 2 also acquires her 1/4 share of Schedule B1 property
Yes.
under the sale deed dated 15/6/1989.
Yeah, now what is that order we are challenging?
Yes, my lord. I'll just a few more preparatory submissions, my lord. What happens in this case? The defendant approaches the plaintiffs and states that he wants to amalgamate a certain set of properties together. Joint development on that property, on that amalgamated property.
Yes.
And asks for me to transfer my rights in that property in return for a 25 lakh payment upfront. And after the development is complete, transfer of 10,000 square feet in my favor.
Yes.
Now, because we're all family members, plaintiff number 2 executes a gift deed for the 2 properties in favor of plaintiff number 1, being her husband. And plaintiff number 1 thereafter executes 2 gift deeds in favor of defendant.
Yes.
Therefore, all the rights get transferred in favor of defendant.
Yes.
And then he makes an application for amalgamation of khata. And we understand that on 4/8/2014, my lord, that is 1 day
Yes.
before the execution of these sale deeds, the sum of 25 lakhs is transferred into my bank account.
Yes.
And bank statement extract that produced along with my claim.
Yes.
On the next day, these 4 gift deeds are executed.
Yes.
And now what happens, my lord? 3 years later, on 2/8/2017, exactly 3 years later, when the so-called limitation is going to conclude, the defendant files OS 5286 of 2017 against plaintiff number 2, seeking recovery of the sum of rupees 25 lakhs, claiming that he has given that money to me, to plaintiff number 2, as a loan to set up a pawnbroking business that I had not repaid. So now when I received these summons, I realized that my consent to the gift deeds was vitiated. Now I put forth one submission. My case is premised on this matter. The gift deeds are a part of a set of reciprocal promises entered into between the plaintiff, whereunder the gift deeds I execute constitute the consideration for the defendant's reciprocal promise that he will pay me 25 lakhs upfront.
Yes.
And we will transfer 10,000 square feet of built-up area. So when I received summons for the recovery suit, I realized that my consent to this entire contract was vitiated by fraud. And therefore, I say that because he's unjustly enriched himself at my expense, I want this entire contract to be set aside, including by seeking the cancellation of these gift deeds which form one arm of the contract. Now, what has happened is that the High Court has not entered into my argument at all.
No,
That
what is that application you have filed?
I filed an application seeking an injunction against them.
Art 39 rule 100. Yes.
The my application is on page 21, my lord, of my appeal memo.
Yes.
My application says, restraining the defendant or anybody claiming from them from alienating or encumbering the suit schedule property pending disposal of the above suit.
Yes.
Now, I will just take my lord to 3 paragraphs in the impugned order to demonstrate how my entire case is misunderstood. At page 51, my lord.
Yes. Yes.
At page 51, the court says, as discussed above, the plaintiffs have sought relief number 2. The judgment and decree to cancel or set aside the gift deed dated 5/8/2014, executed by second plaintiff in favor of the first plaintiff. And fourth, relief to cancel or set aside the registered gift deed dated 5/8/2014, executed by the second plaintiff in favor of the first plaintiff. It is an inconsistent prayer made in the plaint because it is alleged that the plaintiff prays that the court be pleased to pass a judgment and decree in favor of the plaintiffs against the defendant. Further, it appears the plaintiff's inter se cannot seek any relief. The plaintiff in the suit can seek any relief only against the defendant.
No, this is instead of defendant, they have taken as.
No, my lord. I am in fact asking for the cancellation of the gift deeds executed by plaintiff number 2 in favor of plaintiff number 1 and plaintiff number 1 in favor of the defendant. On account of the fact all of these gift deeds, along with the reciprocal consideration that had been offered to me by the defendant, all of them together constitute a composite contract. So I can.
Is it such a suit maintainable?
So I will satisfy this. It will be my endeavor to satisfy this court that such a suit is indeed maintainable. Thereafter, at paragraph 14, the court says, as per contract act, the third party to the contract cannot sue or the second plaintiff executed a registered gift deed out of love and affection in favor of the husband first plaintiff, for which the defendant is a third party. In respect of the registered gift deeds executed by first plaintiff in favor of defendant, the second plaintiff is a third party. Then at para 16, my lord, at the bottom of page 52,
yes,
my lord has it. The
yes,
court says, as per section 123 of the Transfer of Property Act,
yes,
the delivery may be made in the same way as goods sold may be delivered. In that event, the second plaintiff could not deliver the possession of undivided share in suit schedule B1 property, i.e. suit schedule B property in favor of the first plaintiff. In that event, it appears to this court at this stage that the said gift deed executed by second plaintiff in favor of first plaintiff in respect of the suit schedule property is not a valid one. The court at very preliminary stage is arriving at this conclusion. The same is applicable in respect of the registered gift deed executed by first plaintiff in favor of defendant in respect of suit schedule B property. Then at para 18, my lord, the court said as per section 122 of the Transfer of Property Act, gift shall be without any consideration. On leave, my lord, 8th line, for the sake of argument, my lord has the sentence on page 54.
yes,
The 8th line, for the sake of argument.
yes,
For the sake of argument, if at all the contention of the plaintiffs that the said gift deeds were executed in the assurance of the defendant, that the defendant would pay rupees 25 lakhs and 10,000 square feet of built-up area, then the plaintiffs ought to have sought the relief of possession of 10,000 square feet of built-up area. Now, this is the basis on which the court goes on, and then the court says, just above para 20, my lord, the court said I ought to have executed, I could have executed registered deeds in favor of the defendant with certain conditions. And then at page 56, the court says I had not come to the, and the paragraph 22, the 7th line in paragraph 22, nowhere in the CPC. What has that right? At page 56.
yes,
Nowhere in the CPC it is shown that one plaintiff in a suit can seek the relief against another plaintiff. And the learned counsel for the plaintiffs has failed to bring notice of this court in that regard. So these are the conclusions, my lord. This is the reason why my application is dismissed. In short, the court has this to say. Plaintiff number 2 could not have sought any relief against plaintiff number 1.
yes,
That is the first point. Second point is in respect of the undivided share, 1/4 share of Schedule B property. The court understands section 122 of the Transfer of Property Act to say that delivery of immovable property ought to be done as if it is movable property. I will demonstrate by reading of the section as to why that is an incorrect understanding of section 122 of the Transfer. Thereafter, the court says, if in fact such a contract had existed, then I would have sought for recovery of possession of 10,000 square feet, which is a foundational misunderstanding of my case in itself. For this reason, and then the court says, the fourth point.
Now, what is that injunction you have sought?
That they do not create any third-party interest in the scheduled properties pending disposal of the suit.
Yes.
Is the injunction I've sought. The court finds that my gift deeds themselves are not valid, and then the court says that a gift deed must be without consideration. So the moment I say that I have received 25 lakhs, I fly in the face of the statutory injunction to the contrary. And so therefore the court finds against me.
No, that is, see, what the court has given a finding.
I know.
It's not correct because it is nothing but giving in a finding on the merit of the case.
Merit of the case.
Now the question is, admittedly, they are in the position.
No, like my lord, I'm in possession.
No, you have given a gift deed.
No,
You said that you have taken a consideration of 24 lakhs.
25 lakhs. Yes,
25 lakhs. That means to say they are in the possession.
But my
Only your apprehension is that they should not
answer.
create any third party interest.
Yes.
But let us see what we say.
No, I just want to satisfy my court in the position of law under which I'm before the trial.
No, that I am not going to decide whether it is maintainable or not.
Hello.
Suit for injunction,
Hello.
for temporary injunction. Now that prima facie it is appears that they are in the possession of the property.
Hello.
Then you are claiming in a rights over the property. Your rights has to be protected if it is created a third party interest. How it has to be protected, court has to see.
Hello.
Because I am not deciding whether gift deed has to be cancelled, whether suit can be filed against that first plaintiff, the second plaintiff, all that, or if there is a person who is claiming that has no title, then whether injunction can be granted or not. It is admitted that you are an owner, you are given a gift deed, everything.
Hello.
Now that only apprehension is that he may alienate.
Hello.
What he is going to construct? Has he started construction? Not yet. No, actually, whatever do construction, let him do. He can't alienate the third party.
No, my lord, the point that
What will happen if it is constructed? Then he can't claim any equity.
No, I just said I will make one submission here, my lord. What has happened is that if I can just take my lord through some more facts, and then I will.
Yes.
Here is the situation, my lord. Basically, what has happened? I just I seek the indulgence of the 10 minutes. I'll just set out the position of law under which I'm before the trial court in the first instance.
That is what that. What is that? Mistake committed by the trial court? Same thing. You are also doing that. You won't go to that merit. I'm also not hearing. First, I just asked the question whether it is maintainable. Even I can't go it because this is not that stage to hear. This is only for that temporary injunction. See, we have to protect that.
Then I'll just draw my lord's attention just a few
See,
facts.
trial court has gone into that as if, see, on the merit of the case, that would not be arises to consider for. See, if there is any dispute in respect of the title, prima facie title can be going to that at the time of passing that even permanent injunction. Otherwise, that will also not be necessary.
May I just draw my lord's attention to a memo I filed on 4/7/2023.
Yes.
Which was material that had been placed before the trial court at the time of arguments in the IA. And I had produced a memo as annexure G along with my appeal memo.
No,
and I produced the
no,
documents.
see that. You can't do anything at this stage because it is an admitted fact you have given a gift.
No, I just want to.
I will cut short that arguments. Otherwise, unnecessary.
No, I just follow this question.
Now that you can't do it. See, it is not your case that you want to go and put in a construction. Unless suit is decided, you can't do it.
No, my submission is this. My submission is this.
Yes.
If I may just draw my lord's attention to page 23 of the memo dated 4/7/2023.
Here we have produced along with the appeal memo.
I filed it on 4/7/2023. says that they have supporting documents. to
See,
eviction.
now before that, we'll come to that. Where is your application for injunction? Here.
At page 21.
21.
No, I'll just make the submission very.
I will come to that.
Yes.
Let me clarify my doubts myself. What's no, page 20?
1 I feel that.
No, your relief is that not to alienate.
Not to alienate or encumber the associated property pending disposal of the above zone.
No, that I will restrict him not to create third party interest.
Yes.
That is what that yes. Yes.
I just see the automatic paragraph 10 of the upload file at page 23.
Page
23 is the upload.
Yes.
In support of the application.
Yes.
Kindly go to paragraph 10, page 24.
Yes. Yes.
I state that the dividend may alienate and encumber shipping property. The application is not supported with proper argument. That's why it fair price also taken note of it. And it also like order. Paragraph 12.
Yes.
Not all of you. The analysis should take a note of.
Paragraph 12.
So after that, you will be a very issue. You put the upload, otherwise, any property is put the two nature of being mentioned. I made a related by way by any party to for this whole. Whereas in the upload annexed by A1, it goes back. Different way you have income. It is not a case. Rating suit is the rating tag. Is property are in nature of the alien. Because
Wait.
this is a sponsored litigation. It's not a litigation, it is sponsored. Once the list is made, they can't say the list is the subject matter of the prima facie, they have no case.
Their apprehension is that you are filing in a suit for recovery of 25 lakhs. That may be an understanding of gift.
That does not mean that.
No, that legally that is. It is in between the brothers.
If there is a promise of giving them 10,000 square feet of the written area, then they have to balance that. That's what the number of the Supreme Court has said.
Wait.
The gift can be cancelled only on the question of influence. The gift is not the gifts are all not the 1981 Supreme Court. But the gifts are there, I go to cite the judgments. The very itself, the errors are The very grade itself, the foundation.
No, I will grant a time for you if you want to go through that. Wait, yes.
When you want to go to the next copy, letter, I'll be to another.
Only submission is they only move the matter on repeated occasion.
No.
They have just given me the copies.
No, the thing is, one is, it is an apprehension. You are not made clear.
Yeah, my lord.
Second thing is, even if there is an alienation, it is protected under section 52.
My lord, I'll just.
Just because application has been filed, court cannot grant any injunction.
No,
unless
my submission is this, my lord. I believe my submission is that I can satisfy, it would be my endeavor to satisfy.
No,
this
now that
only.
he wants to reply by giving a judgment, you want to go through the judgment and give reply, or
Yes,
you are
sir.
ready to argue
Yes.
today itself?
No, my lord, if they have, tell me what judgments are relying on. they can
No,
make the submission.
is there any order of stay here? No.
This court,
They
yes.
together.
Ah.
It is continue. Only question is because the. Say what I was given liberty to hold the application. I heard the application. Some of the matters are not reached. There are. They could be able to manage taken up today. I will supply all the judgments to my friend.
My lord, I only.
No, see, there are lot of loopholes in this thing. See, let him admittedly, by saying that your application not to alienate, admittedly he is in the possession.
My lord, may I just make.
Wait, madam. You just take it to that. What is that passing in the mind of the court? See, if he construct also, he cannot be alienate. Then you succeed, then he will not claim any equity.
My submission is that.
At least the relief which is not claimed in that application, that we can consider here.
My lord, may I just submit, my lord?
Yes. Still you want to argue that, you argue, we'll see that.
No, my only submission is this.
Yeah.
The defendant is not seeking to construct on that land.
Yes.
The defendant is seeking to create third-party rights in that land by seeking an amalgamation of Karnataka for a set of properties in favor of a third-party developer. Now, my apprehension, my lord, is that if there is no injunction against creation of third-party rights, first of all, my consent has been clearly vitiated by fraud because promises were held out to me, which they had no intention of keeping. Now, it will be my endeavor to satisfy this court only on two fronts. I only crave indulgence of the court to hear me out 15 or 20 minutes, my lord. My submission is this. In the first instance, I will demonstrate how this suit is maintainable under statutory provisions of law. Secondly, I will also demonstrate that there was a lot of material on record before the trial court, showing that there is imminent danger of creation of third-party rights. And that is why I was before the court. Now, the fact of the matter, my lord, is that at the stage of filing an application and an affidavit, my lord would see the circumstances in which I'm doing it. I receive summons in a recovery suit, and I become aware almost immediately that they are going to create third-party rights. I come rushing to court along with an application and affidavit in which I say they may alienate, so therefore I need urgent protection.
No,
now,
that,
it cannot be,
no,
my
that,
lord.
on that ground can be granted. You show me that judgment.
My submission.
Now that legal points, you need not know that may be apprehension.
My submission, my lord, is that there was material on record before the trial court. And I'd also filed detailed written submissions which are a part of the appeal memo, where I had demonstrated to the court what my apprehension was on the basis of documents that had been filed by the defendant before public authorities, which I had obtained certified copies of and produced it before the court. My submission is this, my lord. My lord may call for the trial court records. I will satisfy through the records that I had produced material to show imminent apprehension. I have already filed it under a memo, but I furnished certified copies to the trial court to show imminent apprehension that they are going to create third-party rights. My lord would also see that the great urgency that was motivating my learned friend is because they're on the verge of creating those third-party rights.
Madam,
so to make
law has protected your right under section 52 of if anybody is purchased, it is under their risk.
my lord,
Even the now that somebody has cited that the judgment in that earlier Supreme Court, where it is held, he has been permitted to construct and alienate, but he has intimated that alienate that this is what the Supreme Court said.
I mean, I'm not aware of the citation. I look into it and make submissions. To
Everything you have to see as a counsel, you should be ready.
My only submission is this, my lord. My lord would see this. If the defendant was constructing in the property, it is perhaps stands on a separate footing. But here I have a situation in which he's entered into third-party rights with the, a third-party agreement with the developer in respect of my property. And if he proceeds in terms of, if he executes an agreement with the third-party developer, then it will definitely hinder my rights, my lord. Because I'm not looking at equities only vis-a-vis the defendant. Because in a situation where the defendant creates an equity in favor of himself, he can't rely on it. But now what will happen, my lord, is
where there is a dispute in respect of the title, it's different. Here, you have admitted that you have gifted that property.
my lord, but my submission is this, my lord. I will demonstrate to this court that the gift deed, my lord, is an agreement without consideration, no doubt. But it is a very well settled principle of law that an agreement without consideration can itself form consideration for another promise. That reciprocal promises.
No. Agreement is different. Is a gift deed is different.
No, my lord. I will demonstrate, my lord. If I'm granted an opportunity to satisfy this court, I will demonstrate how under.
No, I'm not going to all these things, madam. I'm not deciding the truth here.
No, I'm not even asking, my lord. I'm not calling upon the court. My
See,
lord.
now that your affidavit says that your apprehension on that ground can be granted, you show me the judgment on that point.
My lord, may I just ask my learned friend to hand over copies of whatever judgments he's relying on? I will also hand over copies of whatever judgments I'm relying on. We'll address the court in 2 days' time.
Yes, Tuesday.
And all copies that they're relying on may be furnished to me, my lord, and I will also furnish copies of all judgments I rely on.
Yes, please.
May I seek the indulgence of this court for Thursday? Tuesday.
Claim itself says that the dispute is executed to enable the defendant to enter into bank development. It's filed 3 years after the deed.
No, my lord, I will satisfy this.
58.
My only submission, my lord.
58.
Wait.
And the second article 58 is really mandatory. Can be filed within 3 years. The date itself is can take the payment.
My lord, 3 years from the date on which my consent, I knew that my consent to the contract was vitiated by fraud. I have pleaded it, my lord. I am also present.
From how many years you have put in this bar?
My lord, the fact is to.
No, I am asking the
My
question.
lord.
From how many years you have put in this bar? How many years? From how many years you are practicing?
Me, ma'am.
Yes.
I'm since 2015.
2015.
If I've caused you offense, I'm sorry.
No. See, when that other side is arguing, see, both are arguing. How can the court decide? From almost your 8 years you have in experience. I thought that you are a newcomer. Yes. See, after hearing that only I can pass an order. But you are taking this matter to as an arguing that suit. Therefore, I am apprehending that you will take more time. This is nothing but an injunction. See, you have given everything on the consent. If he is giving to that builder, all is subject to the result. What will that happen? You are not losing anything, madam. If you succeed, you will get that constructed building. You will get constructed building.
My lord, my submission is this one.
See, what he wants to do it, he can't construct. He wants to enter into that GDA, Joint Development Agreement.
There is no.
See, he wants to do it. That's what it shows that is that urgency they want to do it because see, in that also, let them mention that this is all subject to this suit. If they are unsuccessful, I will make it very clear that they can't claim any equity. You will get that constructed apartments. What else you want? Suppose if you fails, can you ready to give all costs, last cost to him?
One submission. In the plea, I have stated that I am willing to restore the 25 lakhs he's giving to me. Because what has happened is my lord would only.
No. That's he is not saying. He is saying that 25 lakhs is something different and gift deed is something.
My submission, my entire case stands on that. My entire case literally stands on that.
I know that.
Because the fact is that the trial.
See, I understood the case. I know that what will be the answer from the other side? Because this is for the properties they are disputing.
No, my submission is this, my lord. The entire trial, the reason I'm before this court at all is because of the fact that I'm aggrieved by the finding that because a gift deed is without consideration under section 123 of the Transfer Property Act, there is no question of any consideration. So my argument about 25 lakhs is a hoax, and that I'm just basically deceiving the court by coming in on such a flimsy pretext. But my point is this, my lord. I believe that what has happened is that gift deed can form is an agreement without consideration, no doubt. I did not receive any money to execute the gift, but the gift deed itself formed consideration for a set of reciprocal promises made by the defendant under section 2F, my lord. 2E defines every promise as an agreement, and 2F says a set of reciprocal promises constitutes a contract. This has also been interpreted by courts, my lord. Now my submission is this. They come and get these gift deeds executed from me by saying that, listen, I'll give you 25 lakhs, I'll give you 10,000 square feet. 3 years later, just as limitation is ending for their recovery suit, they issue notice to me. This is when I find out that my consent was fraudulently induced. Section 13 of the Contract Act says consent is free consent. 14 says consent is vitiated by XYZ. Fraud is a ground. Section 17 says fraud is when a promise has been held out, which the person who's holding out the promise has no intention of acting upon. One last submission, my lord.
See,
one last submission.
See, unnecessary, I will not allow. See, if you argue all these things, suppose if you succeed.
No, I just want
just answer. If you succeed in this case, all gift deed has been set aside. What will happen? You will get back that property.
No, that's my submission. My
Now
lord.
that you will get back that property with that constructed building.
My lord would see only one thing, which is that there are two suits, 5286 and 132.
E land there is a strong moment and my
lord, my learned friend will traverse far beyond the pleadings, but then we will say that my pleadings are my submission is this, my lord. The fact is there is OS 5286, which is a separate suit. My lord would see, even if I were to succeed in OS 132, what would happen to 5286 is the question, which is not before the court either in MFA or in OS 132. Secondly, what has happened, my lord, is that I agree.
If he wants to argue after going to judgment, I will submit judgment, let it be on Monday.
I just request for Thursday. Tuesday, my lord, I really request for Thursday. If the Lord says Tuesday, I'll be on Tuesday.
Yes, Thursday. Thursday. You cut short your argument. Don't argue like in a suit here. You just concentrating on that. What is issue before this court?
My lord, I just see one sentence of the statement, my lord, because they're not creating third-party insurance in a defined person. They do a development and they build property. They're going to assign it to other third parties, my lord, because once they cheated me on 25 lakhs and my 10,000, now what happens with OS 5286, which is not the subject
that will restrict it. Let them see. He is not at started in with that. After that, they have to construct. Then we will restrict that builder cannot go beyond that for alienating that third party. It is only that he can enter an agreement with that builder. After obtaining the plan, he can construct it. That's all. That flat cannot be alienated to third party till disposal. Then we'll ask the trial court also to dispose the suit early.
Because I have my lord will protect my 10,000 square feet.
There is not a litigation between the family. He is moving forward for another litigation. Who has got a family and it is sponsored litigation. The litigation is conducted by every day. Another gentleman who is
But thing is that that is your brother. It is not a stranger. If it is a stranger, we can say that sponsor. Allah, why they have given a gift deed?
Because see, there are two considerations. That is the father, my father was around to be examined. The money, he had no money. The money I contributed to money. Because these are reasons that we can have a proposition, we have to pay. Now, after 3 years, if they say that there is a promise to 10,000 square feet of built-up area, they have to enforce that promise. That's what Supreme Court said. To enforce that promise, if suppose the money is not paid into the same thing, same is excluded. The vendor said money is not paid. The Supreme Court said you can't seek a cancellation deed, but you have to seek the money that is due. Therefore, if they say that is the wrong, therefore the contract.
My lord, there are two aspects to this, my lord. One is there is a contract. One is there is a contract. The contract is either vitiated or it can be enforced.
Yes,
Now, one
yes.
can say that the argument that a contract is vitiated is not available to me at all.
Yes.
If
Yes.
when my consent has been vitiated by fraud, then why must I go to the level of enforcing a contract in which my consent has been vitiated, my lord? Then they issue against his own brother, against his own brother, he filed a suit for recovery.
Can I decide all these things in that injunction?
My lord, but is it possible to decide his allegations with the fact that it's constant litigation? Is not a prejudice report. Why else would such a
Oh, madam.
allegation even fall?
See, I will decide only on the merit, taking into the interest of the parties. Yes. Close. Kish Kumar. Yes, what is this, Mr. Kumar? Yes. Yes.
Property is purchased by the first responding Ramesh Kumar
Yes.
on 15/5. 2013.
Yes.
The eviction case is filed within 1 year.
Yes.
The eviction case. Within 1 year.
Who is that earlier one?
Here, one was another. The property has fallen to the share of the Sunanda Bai's sister.
You are a tenant under whom?
I was the tenant under the Gauramma's husband.
Yes.
And there was a partition put among them. The property has fallen. This is shop premises.
Yes.
Half of the shop premises has fallen to the share of Sunandamma.
Yes.
And another half has fallen to the share of her sister.
Yes.
The sister of Sunandamma has sold the property to the first petitioner in trial court.
Yes.
The sale was made on 15/5/2013.
Yes.
From Sunita.
Yes.
Can I kindly go to paragraph 6 of the brief?
Yes.
Four 7. 2013 is the suit file, eviction file.
Yes.
Within 2 months from date of purchase. 27
Yeah.
Not maintainable for date of 1 year.
Have you taken the defense before the judge?
Yes,
Has there any issue on that point?
the trial court has not framed any issue, but we have not considered at all.
Yes, but, which is that provision which says you have already vacated from the premises.
What happened was, stay was not continued for some reason.
Yes.
Our simply got a change of taking advantage that they have told you. I have got an application for restoration.
Which is that law which says that within 1 year they can't file it.
What is the judgment clause? ALR 2008 Karnataka 38. Supreme Court of the similar clause is there, Delhi Revenue Control Act. Supreme Court has also said so. Petition cannot be made. Which will contain, therefore, I want to find a synopsis.
Okay, see that is the only point you are raising.
Point. The other point is the mother, see, the premises is 11, 10 by 11 feet.
Yes.
Half is purchased by this first petitioner, first petition trial court. Half was owned by his mother. Mother is dead now. So therefore, he is the only Allah. Her deed has disappeared. Yacha pay on the we don't want to continue, therefore, vacate this.
Immediate possession.
ಪಕ್ಕದ ಅಂಗಡಿ ಖಾಲಿ ಆಯ್ತು during pregnancy ಅದು ಬೇರೆ ಬರಕ್ಕಿಲ್ಲ ಬೇರೆ ಯಾರು ಕೊಟ್ಬಿಟ್ಟು ಅದು ಬರಕ್ಕೆ.
Now that you are interested to get back.
That is my duty out. The cloth area, cloth business area.
What are you doing there in that?
Cloth business.
Our business. Now that they have given that lease out that process.
This is kept vacant. They are not occupied. ಪಕ್ಕದ ಅಂಗಡಿ ಖಾಲಿ ಆಯ್ತು ಅದನ್ನ ಬೇರೆ ಯಾರು ಕೊಟ್ಬಿಟ್ಟು ಅದು ಬೇರೆ. They did not offer that portion also.
Which is that section 31?
21. 21 of 27 RLA. 27.
Without become the landlord in relation to the tenant premises use and provision of possession or. R.
21R. Supreme Court has said so. Check the judgment like it.
Yes, it is there.
Yes.
Which is that judgment?
Restoration of possession.
Now we'll set aside and send it back. Let the trial court decide on that issue.
Position can be restored. Supreme Court has said so.
No,
I've given this because it is not correct on their part to file the exclusion. When the matter is stayed, taking advantage of the fact that on one day stay is not extended.
No, who is that counsel? Satish Kumar?
It is set aside. Direct the trial court to restore the consideration for the restoration.
That after set asiding that, you can go and take for a position.
First restore the position.
Where is that?
I have filed the Supreme Court judgment.
Yes.
I will go to page 48 of the compilation. Para 139. Para 139.
No, you will do think you'll send in a court notice to the party.
Necessary matter is pending. I am out of position.
No, that I am not getting any assistance from the other side.
We can't help it. Therefore, kindly set aside the order. The trial court directed considered by application for restoration. Transfer the application to trial court itself.
No, all that can be permitted under the law.
The court can proceed.
Because The problem is, he is an excavator. He has not been asked to take notice also. That is the-
He has taken notice and all
No,
that.
there is no order. That is the problem is created by court order.
What is number of times he has appeared at
Appeared as an excavator, once notice has been issued, then it has to be directed them to.
Restoration application is filed upon them.
Yes,
They have been served.
yes. In spite
Let
of,
it be set aside. Let it be repeated back to trial court. Consider my application for restoration.
no, you will send a court notice to that party.
That will take long time.
No, we'll fix the date. We'll fix the date.
I am being suffering.
No, that it may, parties may not be aware. These advocates are this thing.
Again, let it be set aside.
No, that I am not getting any assistance, Mr. Student. Yes. In spite of, no, matter has been posted a number of times. Counsel for the petitioner was present. Counsel for the respondent is not present. In the interest of justice, issue court notice to respondent. No, we issue court notice, emergent notice to the issue court notice. Emergent notice under new process. Issue court notice to that respondent. Returnable by 15 days. Returnable by on 22nd. Post this matter on 25th. Yes. Necessary. Let us. No, that see, we need that assistance of two advocates. Then we